Court does call the case of the people of the state of Michigan versus Thomas Gay.
I should call this for the people.
Your Honor, we're going to ask for an adjournment. The prior prosecutor and Mr. Cook and I were in discussion about whether this was resolved or not. It looks like there's still some investigation going on. And
All right.
I will submit a green form.
You don't have one with you at this point. All right. Probable cause conference will be adjourned December 11th, 2025, 9 a.m. Bond will continue. Thank you.
December 22nd. 11, thank you.
I got one.
11.
I got it right. That's all I was saying.
Oh, you get it right. I guess we'll applaud.
Would you please?
No, you got it. Court just called the case. People versus Samuel, Forbes, Allen, Dabney.
People.
Assistant Public Defender Sandra on behalf of Samuel Allen Dabney. Your Honor, there's been a retained counsel. May I go get him? I believe he's in the hallway.
Oh, was he?
Good morning, Judge. Attorney Chair Richard Colonel, we have Mr. Allen Dabney. Appeal number is 42028.
Good morning.
Good morning.
Your name, sir?
Samuel Allen Dabney.
All right. Yeah, it's my understanding that the people are asking for an adjournment.
Okay, that looked like a shock. All right.
Well,
Well, no, hey.
you told me
Yeah.
2 minutes ago. Is that?
You'd want to adjourn.
I believe the fence is asking
Okay.
for an
Well,
adjournment.
no, I'm not. I don't.
It's funny that Miss White is standing up there, not in the middle of the mess. Go ahead.
It's not
For
a mess.
once, I
For
know.
what?
For once.
I'm going to be asking for a preliminary examination, so I don't really need an adjournment. I just need to discover it.
Well, I don't set a preliminary examination until you have to discover.
Okay, well, there you go. So I need an adjournment then.
Okay. Took us a while to get there, but we got there. You want the 4th or the 11th then?
Since the 4th is my birthday, I'm gonna take the 11th.
And I'll set it for the 4th. December 11th, 2025, 9 a.m. Bond will continue.
And I would like to speak
And
to,
I would just wish you happy birthday, but now you're
Thank
gonna
you.
ruin that.
I like
Go
to
ahead.
speak to the matter of bond, Judge.
Yes, sir.
Your Honor, my client, is 26 years old. No prior history, no prior felonies. He's had one DUI that was like 7 years ago, and that is the only thing that is on his record. This incident stemmed from a matter that happened back in February, January. There was in Canton. This stems from a situation that happened in Canton. My client cooperated fully with the authorities back then. When I say fully, I mean fully. He resided at the same place that when he was arrested back in February, where he got arrested, when he was arrested a couple of weeks ago. In July, when he tried to get some of his phone, his laptop back from the authorities in July, the officer told him then that they were still trying to investigate and charge him with the crime. He still didn't try to flee I'm trying to get to the point that he knew that this something may be coming down the pike, but he still resided at the same location and didn't try to flee or anything. I believe the bond currently is $500,000, which might as well be $5 million. I would respectfully ask the court, based upon his non-criminal history and the fact that he did not try to flee, even though he was arrested back in February, was held for a few days. Is that correct? 3 days, fully cooperated with the authorities then, gave statements and everything. And a few months passed. And when he got his phone back or went to try to get his license from the police officers, the detective, they said, hey, we're still investigating. They're trying to charge you with this. Still resided at the same location. When they arrested him, he was at the same location. I would respectfully ask the court to give a more reasonable bond. I know the charges are serious. However, if Mr. Dabney would have wanted to flee, he could have done so for the past 7 months, Judge. He could be in Tahiti right now.
Does he have other felonies pending?
No, no, Judge.
No.
Okay. It's fine.
Your Honor, I would object. It's my understanding from Mr. Kennedy, as I'm covering this case for today, is that at the next PCC, it's our intention to amend the complaint to amend the charges and add charges of aggravated CSAM possession using a computer to commit a crime, as well as CSAM possession. In this case, it does stem from an incident in Canton where the authorities were investigating a different individual. And in that investigation of that individual, they found a video on that individual's phone that had been produced in his basement with an individual on a video who resembles Mr. Alan Dabney sexually assaulting a child. Through that, they got his phone for this investigation and located an overwhelming amount of CSAM on his device.
On Mr.
Yes, and those images include images of children performing sex acts on each other, as well as being sexually assaulted by adults, as well as nude photos. And the report only just gives a small, I guess, preview of that. The report states overwhelming amount of CSAM on his device. So I have extreme concerns given that he was investigated for a video of him sexually assaulting a child, which then led to.
You gotta see, now I like, hold on.
Well,
She just
you
indicated it
need
resembled.
to not interrupt. She
Okay.
did not interrupt
She
you.
just,
No, what did I say?
I understand, Judge.
Go ahead, miss.
And then now they find all these other images and videos on his phone. So I have concerns, would ask that bond remain as set.
What I would like to object to was she indicated it resembles. They had 9 months to determine whether or not this was in fact that a person on the video. And now she's saying resembles, and then 2 minutes later, she said, it is him? I object to that mischaracterization, Judge.
And
And
it was led to him, and then there's CSAM on his phone.
And just as I know it may not matter, but Mr. Alan Dabney was involved with this man in a romantic relationship, and this man that they found the devices, he had possession of his devices, of my client's devices. Cedric Alam, this person stayed in Canton. The authorities was led to this other individual's location. My client was involved romantically with this person that they arrested and charged back in Canton in February. As I already indicated, I understand that the charges are serious, but what I really do not like is that when she says resembles, that means that they don't know if it's him or not. And for the past 7
Maybe that's
months.
the purpose of these proceedings.
I understand, but I don't like the fact that she said resembles and then says it's him.
that led to him, as I'm to understand, and that
Yes, I'll correct what I said. If the report says resembles, we have to talk with Detective Morrison further to see what that video actually entailed, as it was just the first part of the report. So I'll correct what I originally stated. But that video did lead to them getting Mr. Alan Dabney's phone and locating voluminous amounts of CSAM on his device.
anything further.
No, Judge, I just think that a more reasonable bond in this circumstance with no prior criminal history would be more like 100,000, 10%, Your Honor.
Well, given that if it was that individual, but then led to CSAM, which was on his device,
Which was in the possession of his lover.
you wanna, I'll let you go.
Oh, I'm sorry.
No, I'll let you go.
I don't have my
counsel.
rule book
No,
today.
I know you don't have one at all,
I'm not.
and maybe you ought to figure out who does.
I understand. I'm sorry. Get a little excited.
Because this is gonna be a long hearing.
No disrespect, Judge. No
Well, it
disrespect.
was.
Okay.
Given everything that the court has heard, and further that there are additional charges, which I understand are coming in the case, the court does believe that the bond as set is appropriate. Motion for bond reduction is denied. Bond will continue.
Thank you.
Your Honor, just briefly, may I just respectfully ask for the 10% or no?
Bond will continue as set. Thank you.
Thank you.
Yes. Is that supposed to help? Hold on. Nope, doing nothing. Let's see what this brings. Court calls the case People versus Gavin Porter.
Order Assistant Prosecuting Attorney for the People.
Good morning, Your Honor. Paul Taylor appearing for defendant Gavin Albert Porter, who is standing at my right.
Your name, sir?
Gavin Porter, Your Honor.
I have before me a plea form that indicates, is that what we're doing?
Yes.
Yes, Your Honor.
Plea form indicates that the defendant would be pleading guilty to the charge of illegal transport of a firearm in a vehicle, the 90-day offense. Upon a successful plea to that charge, count one would be dismissed. There's further the agreement that the prosecutor will recommend a sentence of no additional upfront jail, and the sentencing judge waiver is, that's the court's full understanding of the agreement.
That's correct.
That's our understanding also, Your Honor.
Not transporting, but unauthorized.
May I have him sworn? This is gonna
Raise your
be-
right hand. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
State your name, please.
Gavin Porter.
Thank you. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of illegal transport of a firearm in or upon a vehicle. That's a misdemeanor punishable by up to 90 days in jail, $100 fine plus court costs, and mandatory forfeiture of the weapon or device. You understand that, sir?
Yes, Your Honor.
All right. Still, and you also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court. You understand that, sir?
Yes, Your Honor.
All right. Still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your Honor.
and because you believe that you are indeed guilty.
Yes, Your Honor.
On the date of September 19, 2025, at the location of 1620 East Medical Center Drive, City of Ann Arbor, Washtenaw County, State of Michigan, were you in a motor vehicle? Were you in a Chevy Silverado?
I own a Chevy Silverado. Yes, Your Honor.
I'm sorry to hear that, but were you in it?
Uh,
I'm a Ford guy, so I had to say it, but
I had my car valeted.
pardon?
I had my car valeted that day. That was it was in the
Got
possession of the valet.
Okay. And in that vehicle, at some point you drove to
Yeah,
the
that's right.
valet.
Yes, Your Honor.
Correct. All right. And in that vehicle, was there a pistol?
Yes, Your Honor.
And where was it located?
In my center council, Your Honor.
All right. And do you have authority to transport that weapon in that fashion?
No, Your Honor.
All
Not
right.
yet, Your Honor.
Pardon?
Not yet. Anyways, I'm trying to get a class on.
Got it. Okay. But at the time you did
No,
not.
I did not.
All right. Sir, if I accept your plea, in this case, court does have to advise you if you commit misconduct between the time of my acceptance of your plea and the time of sentencing, the court would no longer be bound by any recommendation or evaluation in your case, and you would not be entitled to withdraw your plea. You understand that, sir?
Yes, Your Honor.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
People are not, Your Honor.
No, Your Honor, we are not.
And has the court complied with the court rule, and would it be proper to accept this defendant?
People are satisfied, Your Honor.
Defendant is satisfied, Your Honor.
All right, court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
December 19th at 8:30 a.m.
Your Honor, if we may, could it please be pushed into January?
the court over there will be more than happy to do that, I think.
Okay.
Okay, that's the only date I have.
Yeah.
That's the only date I have.
Okay, thank you, Your Honor.
December 19th, 2025. What time?
8:30.
At 8:30. Bond in this matter will continue unless you want to make an argument. No, go ahead.
Thank you very much.
Thank you, sir. Have a good holiday.
Happy Thanksgiving.
Court does call the case. People versus Devon Galliard.
Hey, Alexander, on behalf of people.
And good morning, Your Honor. Attorney Maxwell Dubin, P number 86012, on behalf of Mr. Gilliard.
Sir, can you state your name?
Devon Gilliard.
Thank you. All right, what are we doing in this case?
Your Honor, today's the date and time set for PCC. I'm asking for an adjournment of the PCC, and then if I'm able to address bond, Your Honor.
Yeah. You want I can do December 4th or the 11th. He's in custody, so I'm going to go to the 4th. Okay. Probable cause conference, December 4th, 2025, 9 a.m. Esteban.
Your Honor, I believe this court may recall this case. At the last hearing, you revoked bond. My client was intending to, or was granted previously to go to Texas. He did not go to Texas. He returned to Georgia, subsequently revoking bond to a no bond warrant. I want this court to know first and foremost that my client is not here to make any excuses, reasons. He understands that when a court puts in an order, that order must be followed to a T. It doesn't matter what mistakes you make or what you think. Everything needs to be, every I needs to be dotted and every T needs to be crossed. Okay, Your Honor, that being said, I would point out that my client does not have a history, a criminal history whatsoever, pretty much, and he's never been on a tether prior to this. He did make a mistake. He is owning up to that, Your Honor. What I'm asking here today is that this court either allow him a second chance to prove himself, and in the alternative, give him some type of attainable cash bond. When you did revoke bond, I know it's obviously court ordered. I will point out that my client immediately drove from Georgia, made arrangements, and turned himself in immediately, showing that he can abide by any rule sanction that this court puts upon him. Just to give some clarity, not as an excuse, the reason he did not return to Texas, Your Honor, is my client was in the military.
I lost you, counsel. I can't hear you.
Can you hear me now, Your Honor?
I can.
Which part did you lose me at?
I don't know because I didn't hear it.
Okay, well, okay. Well, in short, Your Honor, just some background. Besides, my client does not have a criminal history. This is his first time dealing with something like this. He did not return to Texas, and this is not an excuse. He did not return to Texas. His intention was to. That being said, the military, which he was in prior, actually shipped his stuff to Georgia, to his mother's house. That was the reason he did go to Georgia and went to Georgia. What we're asking here today is an attainable cash bond and or a second chance to prove to you that he can abide by any rule sanction that you would put upon him, Your Honor.
Any response from the people?
Your Honor, at this point, I'm going to object. I don't know. I have concerns. I don't know exactly what he would be saying if he's released. I have concerns that he was given the chance to go to Texas. He told the court and the people he was going to Texas. He didn't go to Texas. He went to North Carolina, South Carolina, Georgia, never went to Texas. And I have concerns that if he's released, he's just going to go wherever he wants. And he said last time during the hearing that since he's on the tether, he could just go wherever he wanted. And then I have concerns given that he went to Georgia and the argument was that if something came up for court, like an exam or a hearing, he had to attend in person, he would be there in person. He wasn't here last time in person. He was in Zoom. The only way we got him here in person was that he had to turn himself in on a no bond warrant. So I have concerns that this time I don't have enough information on where he'll be staying, what those terms of bond will look like when he gets out, because I don't know if he's going to try to go back to Georgia or if he's going to try to go back to Texas. I just don't know. So at this point, I'm going to object.
Anything else?
Yeah, if I may respond briefly, Your Honor, if my client is given bond, he will stay and remain in Georgia and even come back in person.
How do I know that?
Well, if I may,
mean, because the last time he told me he was going to reside in Texas, and I let him leave, and he never set foot in Texas.
And if I may just respond to how you would know that, Your Honor, besides the fact that he's on tether, he was very upfront with the tether, with probation. He didn't lie. He didn't try to say he was in Texas when he wasn't. He was very candid with them when they asked. And he knew he was being tracked and monitored. Your Honor. So his intention was not to deceive you in any way. But that being said, I and my client understands why the court did what they did in revoking his bond. I want this court to understand that my client is attempting to be very candid and upfront. He's not running away. And the reason, if I may respond to the prosecutor, that he appeared via Zoom is because he couldn't get here in time. So I had him log on because he didn't want to not appear at all. And then, of course, subsequently his bond was revoked and he immediately came back. He's not running from this, Your Honor.
At this point, the defendant's bond will continue as revoked. I let him leave. He told me where he was going. He's now trying to, and never went there. And now he's trying to tell me he's going to some other place. I have no idea. I can't believe this defendant. I can't trust that he's going to do what he says he's going to do. So the motion for bond reduction or bond in this case is denied. This matter is adjourned to December 4th. Thank you.
Thank you for hearing me out, Your Honor. And I hope you have a good rest of your day as always.
You do the same, sir. Well, look what the cat drug in. That's why stuff started out wrong. Childers was around in the building. I felt something. That's why my day has started. Mr. Childers, how are you, sir?
Well, Judge, thank you for asking.
And your family is doing well?
Very, very well.
I'm glad to hear that. Welcome back.
Good to be back.
I'm happy to have you back. These people have been out of control. No, it's been really bad. We'll talk. Anyway, court does call the case of the people versus Zipporah Morgan.
Good
morning, Your Honor. Jonathan Sachs for Ms. Morgan, who is appearing via Zoom from Georgia. Supposed to be.
Is she really?
Yep. Ms. Morgan.
Did you see that last guy there? No kidding. Don't answer. Anyway. State your name, ma'am.
Zipporah Morgan.
Thank you. I have before me a plea form. Is that what we're doing?
It is, Your Honor. We have a negotiated plea worked out for a deferred sentence and a misdemeanor disposition.
The plea form indicates that the defendant will be pleading guilty to the charge of improper possession of a firearm in or upon a vehicle. The 90-day offense. Upon her successful plea to that charge, count one would be dismissed. There is a sentence agreement of a deferred sentence pursuant to 771.1. That's the court's full understanding of the agreement.
That's correct.
That's correct, Your Honor. Thank you.
Ma'am, can you please raise your right hand? Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yeah.
State your name for the record, please. You muted.
Zipporah Morgan.
All right. You can put your hand down. Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of improper possession of a firearm in or upon a motor vehicle. That's a misdemeanor punishable by up to 90 days in jail, $100 fine plus court cost, and mandatory forfeiture of the weapon or device. You understand that?
Yes, sir.
You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Yes, Your Honor.
Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed gave permission to sign a advice of rights form, is that correct?
Yes, sir.
Do you have any questions regarding any of the rights on that form?
No.
With particular attention to paragraph 5, those are your trial rights. You understand that you're waiving or giving up all of the rights that are contained on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes.
And also because you believe that you're guilty of this offense?
Yes.
On October 26, 2025, at the location of 579 Eugene Street in Ypsilanti Township, Washtenaw County, State of Michigan, were you operating a motor vehicle or in a motor vehicle?
I was getting out of a motor vehicle. Yes.
And in that motor vehicle, or while you were getting out on your person, was there a firearm?
Yes.
Was it yours?
Yes, sir.
And where was it located?
In the middle console of my car.
All right. Did you have authority to carry that weapon in that fashion?
No, I did not.
All right. Ma'am, if I accept your plea and you commit misconduct between the time of my acceptance of your plea and the time of sentencing, I do have to advise you that the court would no longer be bound by any evaluation or recommendation regarding your sentence, and you would not be entitled to withdraw your plea. You understand all of that?
Yes, sir.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
I am not, Your Honor.
And have I complied with the court rule? Would it be proper to accept this defendant's plea?
You will satisfy, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered. Sentencing in this matter will be
January 15th at 10 a.m.
January 15th, 2025, 10 a.m. That is before Judge Washington. Bond in this matter will continue. Happy Thanksgiving. Thank you.
Thank you, sir. You too.
Happy Thanksgiving, Your Honor, to you and the court, to the prosecutors, and especially the public defenders.
Anybody else you want to bring into that? And happy Thanksgiving to you, counsel. Court does call the case People versus Robert Barnett.
Yes, call this for people.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Barnett. State your name for the record, please, sir.
Robert Barnett. Next time, Perry, when they won't let you do it, just push it.
I think Your Honor has a couple documents in front of you. There's a exam waiver on both cases.
There is.
And I would ask Ms. Feltus to put the agreement on the record. And there's also an order for release to treatment. I think at Mr. Barnett's previous hearing, Your Honor stated that he could be released to treatment. I don't think an order ever made its way to the court. So that is why I have submitted that today.
All right, very good. And just to clarify that order, and then I'll let you put everything on that order without a GPS.
I can add that if the people in the court want.
I would like that.
Yeah, typically, so that you're aware, I typically require that unless there's some reason the facility won't allow that.
Would you like me to add it and resubmit?
Yes, please. All right, and then I would sign off on that.
And the offer that was extended to the defendant was, if he did waive the exam, he would have the opportunity in circuit court to plead case 24F20965, which is the stolen vehicle case, and dismiss 25F55793 case, which is the drug possession case. There are no other agreements.
Got it. And counsel, just so that, because at the point I'm going to lose jurisdiction, so you may want to just write it on here and submit it to the court today.
Okay.
Okay. So you're waiving your right to hold a preliminary examination?
Yes, sir.
You understand a preliminary examination is a proceeding by which people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution?
Yes.
People waive their right to a preliminary examination in both cases?
Yes, Your Honor.
Preliminary examination having been waived, defendant over to circuit court on the single count in each case.
Your Honor, we acknowledge receipt, waive formal reading, and stand mute, please.
Defendant having waived formal reading, standing mute, the court will enter a not guilty plea. Pretrial will be set for
December 18th at 1:30 with Judge Slay.
December 18th, 2025, 1:30, Judge Slay.
And I think the court wanted me to add that GPS tether provision to the,
The one you submitted.
this is the waiver form.
Oh. Gave her back the one she did right. Is that?
No, you haven't.
1 for 2 is not bad.
December 23rd, 2023, 25.
December
One,
18th.
December 18th. What did I say?
23rd.
That's because she kept messing me up. December 18th, 2025, 1:30 before Judge Slay. Bond in these matters will continue.
I'll take it.
Thank you. Since I don't know where. Court does call the case People versus Martina Smith.
Water Assistant Prosecuting Attorney for the People.
Good morning, man. Please, this Honorable Court, Kareem Johnson, on behalf of Ms. Smith, who is present and approaching to my right.
Morning.
Morning, Mr. All right. What are we doing?
Your Honor, we are asking that this court set this matter out for a preliminary examination. I'm asking for some additional time, though I do have all discovery. There is a issue I need to follow up on, and it may lead to a better resolution for my client.
But as for the discovery you have from the people, you have that now.
Yes, what I need to follow up is not in possession of the government.
Got it. And how much more time, sir, would you need? Hey,
Probably a week,
I would
extra
be
week.
setting these for the 9th, correct?
Yes.
I would be setting these for the 9th, so I've got the 16th, 23rd,
I'd ask for the 23rd. The 9th, I'm in a homicide trial in Ingham County.
23rd.
Yes, sir, please.
People have their witnesses available the 23rd.
We'll do our best.
Preliminary examination in person, December 23rd, 2025, 12 noon. That's before me. Bond will continue. Thank you. Is that it for you, sir?
Yes, sir, it is, Your Honor. Thank you.
Please, on a separate matter.
Your Honor, is that exam before this court?
Yes,
Thank you.
before me. Mr. Jones, you can approach, please, on a separate matter.
Water Assistant Prosecuting Attorney for the People.
Brian Rolling on behalf of Ms. Campbell, who's approaching, Judge. Good morning. Can you state your name, please?
Michelle Campbell.
Thank you.
Judge, I met with Ms. Campbell yesterday at the jail. We're asking for an adjournment to see if we can try to work out a global resolution of all of our matters pending in this county.
All right. Will December 4th give you enough time to do that?
I hope so. We'll
All
try.
Okay. Probable cause conference will be adjourned December 4th, 2025, 9 a.m.
Thank you, Your Honor.
Bond will continue. Court calls case People versus Julia Abiano.
Good morning, Your Honor. Corey Silverstein appearing on behalf of the defendant.
Abiano, can you state your name, please? Probably need to
Julia
unmute.
Labiano.
There we go. Thank you. What are we doing?
Good morning, Judge. Your Honor, this is a case that has a mental health element to it. Originally, what we had discussed doing was we were going to do a referral to the mental health court, but unfortunately, Ms. Labiano can't establish residency in Washtenaw County right now, which has caused a little bit of a hiccup. So I do need to speak with the prosecutor again. I'm not sure which prosecutor it is because the last time we were with you in person, you had the deputy prosecutor was in your courtroom and we were working with her. I don't know who's handling the case now.
Is she's not a resident in Washtenaw? Is that the issue?
That's the issue, Your Honor. What we were trying to do was I was talking to your court clerk and they were talking to mental health and we were trying to see if there was a way we could make it work. Because this is
Got
an
it.
individual who could truly benefit from the program, but unfortunately, we just haven't been able to get her a physical address in Washtenaw County that would work. So it seems like me and the prosecutor still have some work to do here. Like I said to you before, I'm not quite sure which prosecutor is handling the case.
I'm the prosecutor assigned to it now, so you can reach out to the office and ask to speak to Kenneth Overwater, and we can discuss that.
Oh, fantastic. Can you give me your last name one more time? Forgive me, it was a little hard to hear.
Overwater.
Fantastic. Yep,
Turn
so
this matter out to December 18th, 2025, 9 a.m.
That's
There is
perfect.
another issue. I'm not sure exactly when this happened, but Ms. Laviano has been charged with a misdemeanor domestic violence charge. She's not yet been arraigned on that, and there is a warrant outstanding on it.
Out of what jurisdiction?
That would be, I believe, 15th District Court.
Okay, we're not going to have the complaint. You heard that, counsel?
I did, Your Honor, and this actually was an incident that predated this one. So what we're doing is we're making arrangements. I've already spoken to the 15th District. We're working on making arrangements to get that bench warrant cleared up.
Good. December 18th, 2025, 9 a.m. bond in this matter will continue. Thank you.
Your Honor, does the court have any issue with us appearing again on the 18th by Zoom?
If you submit the forms, we'll consider it.
Sounds
Thank you.
perfect. Thanks, Judge.
Court calls case People versus Rontrell Davis.
Ashley Feltes for the people.
Assistant Public Defender Chelsea Vergils with and on behalf of Rontrell Davis. Mr. Davis, state your name.
Rontrell Davis.
We are asking to adjourn this we're waiting on media discovery for a court date before December 18th, if possible.
Pardon?
Is it possible to set the next court date before December 18th? He has another court date then.
Sure. Will the 4th work?
I believe so, yeah.
Probable cause conference, December 4th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court calls case People versus Javante Poplar.
Overwater, Assistant Prosecuting Attorney for the people.
Sherilyn Foster Tucker on behalf of Javante Poplar, who should be on the Zoom.
Oh, there he is. State your name, sir.
Javante Poplar.
All right.
And Your Honor, we're requesting an exam in this matter.
We're on the 9th, is that right?
Yes.
Discovery is complete.
To my knowledge.
People have their witnesses available the 9th.
I expect we shall.
Preliminary examination in person, December 9th, 2025, 9 a.m. That's before Judge Valvo.
Is that still in the same courtroom, Your Honor?
Pardon?
Is that still the same courtroom?
Same courthouse.
Oh, yeah, courthouse. Yeah. Okay. Thank you.
Bond will continue. Thank you.
Thank you, Your Honor.
Court does call the case People versus Matthew Melzo.
Overwater, Assistant Prosecuting Attorney for the people.
Assistant Public Defender Natalie, on behalf of Mr. Melzo, who is approaching.
Please state your name for the record, sir.
Matthew Melzo.
Thank you. You're requesting an adjournment.
Yes, Your Honor, there is some still outstanding media discovery that hopefully I will get soon, so I'm asking for an adjournment of the probable cause conference to make sure we.
Matter will be adjourned December 4th, 2025, 9 a.m.
Thank you, Your Honor.
Bond continues. Thank you. Court calls the case People versus Earl Williams.
Overwater, Assistant Prosecuting Attorney for the people.
Sherilyn Foster Tucker on behalf of Earl Williams.
Your name? Earl Williams. All right, I have before me a plea form. Is that what we're doing?
Yes, Your Honor.
Plea form indicates the defendant will be pleading to an added count two of false pretenses, 200 to 1,000, the 1-year offense. Upon a successful plea to that charge, count one would be dismissed. There's a sentence agreement of a sentence under the Home to Fill Trainee Act. That is the court's full understanding of the agreement. Is that correct?
That is correct, Your Honor.
That is correct, Your Honor.
May I have him sworn?
Right hand. Do you solemnly swear in affirm the testimony you're about to give the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name.
Earl Williams.
Sir, it is this court's understanding that you are going to be pleading guilty to the charge of false pretenses, 200 to 1,000. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The court would further have to advise you that the fine can be increased to 3 times the value of the property, which is the subject matter of the crime. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
Yes, sir.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 1483 District Court.
Yes, sir.
Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Sir.
You signed an advice of rights form, is that correct?
Sir.
Any question regarding any of those rights?
Sir.
Please look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, sir.
And also because you believe that you are indeed guilty of this offense?
Wait, can you repeat that for me?
You're also pleading guilty because you believe that you're guilty of this offense?
Do you believe you're guilty of this offense?
Oh, yes, sir. Yes, sir.
October 11th, 2025, at the location of, well, I don't really have a location. The city of Chelsea, Washtenaw County, state of Michigan. What do you do that makes you think that you're guilty?
Use counterfeit money to purchase stuff at stores.
All right, so you had money that you knew was counterfeit?
Yes, sir.
And you used that money to purchase items at various places?
Yes, sir.
All right. The amount of these purchases or the amount of counterfeit bills that you intended on passing or bought those items with, was it more than $200?
No, sir.
What's the amount of money that you got back?
Or like 50.
Pardon?
Probably like 50.
So you only used $50 of counterfeit bills?
So I used probably like around 300.
Which is a bigger number than 2, right?
Yes, sir.
Yeah, okay. All right. Maybe not in counterfeit, I don't know. All right. And so, and your intent was to mislead these various places and or businesses that the monies that you were giving them was real. Is that correct?
Sir.
Sir, I do have to advise you that if between the time of my taking your plea and the time of your sentencing, if you commit misconduct as defined under the Michigan court rules, the court would no longer be bound by any recommendation or sentence evaluation, and you would not be entitled to withdraw your plea. You understand that, sir?
Yes, sir.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
Big one out.
No, Your Honor.
And have I complied with the court rule?
People are satisfied, Your Honor.
Satisfied, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A3 probation. Sentencing in this matter will be January 5th, 2026, 9 a.m. That's before Judge Freshour. Bond will continue.
And Your Honor, if I may just address bond briefly, Mr. Williams is on a GPS tether. I don't believe that there have been any violations of that tether that I've been made aware of, and he has appeared for all of his court dates. He asked that the court considers removing the GPS tether.
Any response from people? Not that I need one. I don't need a response. Motion is denied. I'm gonna continue to tether.
Thank you,
Thank
Your
you.
Honor.
I think she's. Court does call the case, People versus Allen Rogers.
Jennifer Waters, Assistant Prosecutor.
Sandra White on behalf of Alan Rogers.
Your name, sir?
Alan Rogers.
Thank you.
Your Honor, I'm asking for an adjournment for further negotiations with the prosecutor.
Probable cause conference will be adjourned December 4th, 2025. And bond in this matter will continue. Thank you. Court calls case People versus Joel Serbinoff.
Jennifer Waters, Assistant Prosecutor.
However, on behalf of Mr. Serbinoff, who's appearing by Zoom. Serbinoff, please unmute yourself, turn on your camera, state your name for the court.
Joel Serbinoff.
Judge, today is the date and time set for probable cause conference. We are working on an offer, trying to get Mr. Serbinoff into treatment court. So we are asking for an adjournment at this time.
Probable cause conference will be adjourned December 11th, 2025, 9 a.m. Bond will continue.
Thank you, Judge. You're free.
Thank you, Your Honor.
Thank you, sir. Court calls case People versus Kevin Smith.
Feltes for the people.
Good morning, Your Honor. Assistant Public Defender Davi Leva for Mr. Smith, who stands to my right. Mr. Smith, could you please tell the court your name, sir?
Kevin LeBron Smith.
What are we doing?
Your Honor, I'd like to request an adjournment, and I'd also like to address bond, please.
December 4th, 2025, 9 a.m. as to bond.
Thank you, Your Honor. So I just talked to Mr. Smith yesterday. He tells me that he's suffering from bipolar schizophrenia and does need medication for that. He could stay with his mother if released. We would have no objection to a home confinement tether to ensure his appearance at court, which I believe was the reason for his remand. I would note this is a non-violent case where the allegations are simply theft of books from a library. And I do believe that a tether would ameliorate any concerns regarding the previous failure to appear.
Response.
As defense counsel stated, previous failure to appear. I believe we were looking at mental health treatment court for this person. That was the goal of the people, was to get him into that specialty court so we could have support necessary. Concern anything at this time before he's trained in acceptance of treatment court would not set him up for success. I would ask that the court continue the bond train the next 10 days and we'll be able to.
Motion for bond reduction is denied. Bond will continue.
Thank you, Your Honor.
Court calls case People versus Antoine Thomas. Sir, you got to keep moving.
Ashley Feltes for the people.
Carbadell on behalf of Mr. Thomas, who's approaching the podium, and will be standing to my right. Mr. Thomas, when you go up here, please state your name for the record.
Antoine D'Angelo Thomas.
Thank you. Take your hands out of your topics, please.
Your Honor, today is the date and time set for probable cause conference. Again, similar to my last case, we are working on getting Mr. Thomas involved in treatment court. So we are asking that for a brief adjournment at this time. It is out county, so a bit of an extended.
December 11th, 2025, 9 a.m. Bond continue. Court calls case of the People versus Bonnie St. John.
Ashley Feltes for the people.
Good morning, Assistant Public Defender Lauren Perry on behalf of Ms. St. John. Ms. St. John, state your name for the record.
I'm St. John.
Thank you.
Your Honor, we are asking for an adjournment of the PCC for negotiations, and I would like to address bond.
Probable cause conference will be adjourned to December 4th, 2025, 9 a.m. as to bond.
Your Honor, Ms. St. John is requesting a personal bond. She has a number of reasons why she would like to go home. The most important is her medical conditions. She has Parkinson's that is worsening daily. She is on a number of medications for that. She also has diabetes, significant pain that she deals with. And she's also undergoing testing for potential cancer. Those things are obviously hard to do in the jail. And so Ms. St. John would like you to take that into consideration. This case is a drug case. She has set up treatment at Gretchen's place in Belleville. She was about to go there when she was picked up on this warrant. So if
Is that before or after her use of cocaine?
I believe that was after.
Oh,
She organized that treatment. So if she were to be released, she would be attending classes there. She's also engaged in therapy, I believe.
Yeah.
If she were to be released, she would go home to her husband who helps care for her. They're both retired. I think Miss St. John did have a failure to appear. I think she had she didn't go to community corrections within a certain amount of time. From talks with her husband
and she went to community corrections, tested positive twice for cocaine use.
Yes. From the talks with her husband, apparently her memory from the Parkinson's is significantly affected. So knowing that moving forward, we'll make other efforts to get in touch with Miss St. John to remind her of everything she needs to do while out on bond.
Don't need a response with all of that, and considering everything, and defendant's continued use of narcotics in violation of bond. Motion for bond reduction denied. Bond will continue. Court calls case People versus, is it Micah Williams?
Hi. It's Micah.
Prosecuting attorney People.
Carville on behalf of Ms. Williams. Ms. Williams, please state your name for the record.
Micah Williams.
Thank you.
Judge, today is the date and time set for probable cause conference. We are asking for an adjournment. The court should be in receipt of the green sheet.
Probable cause conference, December 4th, 2025, 9 a.m.
December 4th, you said, Judge?
Yes.
Thank you.
Bond continued.
All right.
Thank you, Ms. Williams.
We'll be in touch.
Okay.
Court calls case People versus Procopio Vitale.
Morning, Your Honor. Michael Gaddy, Assistant Public Defender on behalf of Mr. Vitale, who's here to my right.
Procopio Vitale. What are we doing?
Your Honor, we're seeking a very brief adjournment. Mr. Vitale has cleared the first hurdle to the drug court. They are coming, it's my understanding they're coming to interview him personally at the jail in the next few days.
Few days.
Yes. Yeah, I mean, they said this week, but it's a short week, so I would bet early next week, Judge.
You think everything will be accomplished by the 4th, or?
Maybe we should do the 11th just to be sure.
Be sure.
I think he sees Judge Slade for some reason, oddly on the 5th. I don't know why, but.
Okay. All right. I'll adjourn both of these to December 11th, 2025, 9 a.m.
Thank you, Your Honor.
Court calls case People versus Deveron Anderson.
Sorry, Your Honor, Assistant Public Defender Chelsea Regiels with and on behalf of Ron Anderson. Please state your name.
Deveron Anderson. You're getting more and more like I can really.
I'm sorry, Your Honor.
Yeah. Wow. Wow. What's wrong? I know, because she knows how much that would irritate. She's doing the right thing. She's good.
I'm doing my best, Your Honor. Thank you for your patience. In this case, we'd just like to set a preliminary exam.
Discovery is complete.
To the best of my knowledge, it is, Your Honor.
People have their witnesses available tonight.
I believe so.
Preliminary examination in person, December 9th, 2025 at 9 a.m. before Judge Washington. Bond will continue. Thank you.
Thank you, Your Honor.
Mr. Bowling and I approached on an urgent matter.
Yes, you may. Deveron Anderson. I did that one. Court does call the case of the people versus Aaron Davis.
Tenth Order, Assistant Prosecuting Attorney for the People.
Good morning, Judge Christopher Quinn, appearing on behalf of Mr. Davis.
Your name?
Aaron Davis.
All right, what are we doing?
Do you have a resolution in this matter? I just prepared a plea form. I can print that, give it to counsel, and we can do it today, or we could get it another day, whatever the court will do.
You just did it. Where is it?
I would need to print it.
Pass it.
Thank you.
Court calls the case people versus Rick Artuso.
Tenth Order, Assistant Prosecuting Attorney for the People.
Assistant Public Defender Natalie. Who's approaching? Please state your name for the record, sir.
Rick Artuso?
Thank you, Your Honor. Your Honor should be in receipt of a green sheet. We are respectfully requesting an adjournment. I did get some updated contact information from my client this morning.
Probable cause conference will be adjourned December 11th, 2025, 9 a.m. Bond continued. Thank you.
Very much, Your Honor.
Court calls case people versus Lorraine Atkins.
Brian Bowley on behalf of Mr. Atkins, Your Honor.
Larry,
just state your name.
dang, you know, I said last time, I said, I'm gonna get it right. I'm gonna get it right. I committed it to memory. I just left.
Larry Atkins.
I don't think that's his name. I'm gonna sign an order changing it. That way I'll be right. All right.
Because we have a resolution, there's a
Yes.
plea form before you and also an assigned advice and rights.
All right. The plea form indicates that the defendant will be pleading guilty to the charge of false report of a misdemeanor to 93-day offense. Upon a successful plea to that charge, count one would be dismissed. That's the court's full understanding of it. Is that correct, counsel?
That's correct.
May I have him sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony about to give you the truth, the whole truth, and nothing but the truth? So help you God?
Yes.
State your name.
Larry Atkins.
Sir, it is this court's understanding you're going to plead guilty to a misdemeanor charge of false report of a misdemeanor. That is itself a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. You understand that, sir?
Yes.
You also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B district.
Yes.
Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights contained on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Yes.
Which one?
Probation.
You're on probation. Were you on probation at the time of this offense? No. All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will. And because you believe that you're guilty of this offense?
Yes.
On December 21st, 2023, at the location of 7080 Collins, Colchester, I guess, Lane, Ypsilanti Township, Washtenaw County, State of Michigan, what'd you do on that date that makes you think that you're guilty?
I phoned the police about some money missing from my bank account that I didn't realize I authorized to give out. I was inebriated at the time and didn't remember, but over time it came back to me that I did do that. And so
at the time you called the police, you did not know it to be false?
No, I did not.
And was there a point after you knew that to be false that you failed to notify the police of that?
I guess so, yes. Well,
I don't. Council approach, please.
Yes.
Court has a, there's been a bench conference, brief bench conference in case court will pass this matter.
Thanks, Judge.
All right, thank you. Court does call the case People versus Dylan Chapman.
Alex, on behalf of the people, Your Honor.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Chapman, who stands to my right, please state your name for the record.
Dylan Chapman.
Thank you, Your Honor. Your Honor should be in receipt of a green sheet. I have spoken to the people regarding this. We still do not have the 911 call or media discovery in this case. It has been requested by the people, so I'd request an adjournment.
And that's correct, Your Honor. We don't have the media either, so I couldn't.
Oh, you don't? Okay. December 11th, 2025, 9 a.m. Bond continued.
Thank you.
Thank you, Your Honor.
Court calls case of the People versus Moses Cunningham Page.
Assistant Public Defender Chelsea Virgils with and on behalf of Moses Coonigan Page, who approaches. Please state your name.
Moses Cunningham Page.
Thank you.
Your Honor, we're asking for a brief adjournment in this case just to continue going over the discovery with our client.
Probable cause conference December 4th, 2025, 9 a.m. Bond continued. Thank you, sir.
Thank you.
Thank you, Your Honor.
Court calls case People versus Amiri Davis.
Assistant Public Defender Sandra White on behalf of Davis, who I believe appears by Zoom.
Yes. Sir, state your name, please.
Amir Davis.
Your Honor, there has been an offer extended by the people. I need to discuss this with Mr. Davis, so I'm asking for an adjournment.
Probable cause conference will be adjourned December 4th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
Thank you, sir. Court calls case People versus Tegan Donald.
Assistant Public Defender Donnie Lebo for Ms. Donald, who appears via Zoom. Ms. Donald, could you state your name, ma'am?
Tegan Summerstrader, Donnell.
Thank you.
And we're going to be requesting adjournment. Ms. Donald is presently hospitalized.
Okay.
I will be being released today, and I was asking if I should report to community corrections tomorrow.
Gotcha. Okay. So you're hoping to be released today?
That's the hope.
Okay, understood. Probable cause conference will be adjourned December 11th, 2025, 9 a.m. Bond will continue. All right.
Thank you, Your Honor. And Ms. Donnell was inquiring whether she needs to report to community corrections upon her release.
She's not reported. Yes, she does.
Thank
I
you,
haven't.
Ms. Donnell.
I haven't been able to.
Okay. All right. Thank you.
Thank you.
Thank you, ma'am.
very
Be
much,
well.
Rhonda.
Court calls case People versus Karen Skinyard.
Mentor Water, Assistant Prosecuting Attorney for the People.
Good morning, Assistant Public Defender Lauren Penny on behalf of Mr. Ginyard. Thank you. Mr. Ginyard, state your name for the record, please.
Terrence Ginyard.
Why is he wearing that M that I don't like right now?
It's a big week for us.
It's nice color, I guess. He does work at U of M, Your Honor, so it might be part of his
So?
dress code.
So, he took it off? No, he didn't.
My apologies, Your Honor.
Okay, it was a bad weekend for me.
Yes, sir.
And you're just bringing it all up.
My apologies.
No, you don't care. All right.
So, Your Honor, we are waiting on discovery. Spoke with people, I think it's on its way. There's also, Mr. Ginyard also has to be arraigned on the count 1.
Yes, which counts?
There's amended count 1, yeah.
I didn't see this. What was it? Ah, okay. So as to count 1,
We'll waive formal reading, stand mute to the charge.
All right, defendant arraigned on count one. The court stood mute. Court will enter a not guilty plea.
And Your Honor, regarding the adjournment, Mr. Ginyard recently had a child. That child is in the NICU and the child's not doing well. The status is kind of precarious. So he would like to request a bit of a longer adjournment.
Any objection from the people?
I wouldn't have an objection to a longer adjournment, however. Bond violation may not be, because I just by email.
What is it?
I'm not in receipt of anything either.
Well, I'm in receipt of a report that indicates that as far as the SoberLink device that Mr. Ginyard has found, that he was late for a test on the 18th, tested negative. On the 20th, he missed a test, but later tested negative. More concerning, on the 22nd, he missed a test, later tested positive with a VAC of 0.027, and then missed a retest at 12:19, 12:42, 1:19, 1:49, 2:19. Well, it says 2:19 twice. So there was a positive test and then several missed tests after that. People are concerned there was an open alcohol container in the vehicle when Mr. Ginyard was pulled over. And then later a firearm was found in the car as well, which is the basis of these charges. People have concerns about his alcohol use.
Well, Your Honor, I haven't spoken with Mr. Ginyard about the bond violation. I also haven't seen the discovery to respond to the allegation. I don't know why he's, yeah.
I'm sorry, sir.
I'm sorry, Your Honor. I haven't had any alcohol since I've been home. I have this tether on my leg. I've been doing this this silver leaf thing, and I haven't took any type of drug since I've been home. I've been working 6 days a week.
Mr. Ginyard, hold on one second, please.
He's going to need to get down here today because his Zoom privileges that would have been revoked.
Okay, I'm going to call you, Mr. Ginyard, right now.
So I'll pass it, but I'll recall it sometime, likely around noon, but I've got some leeway this afternoon.
Okay.
All right. Thank you. Court calls case People versus Renee Hall.
Ashley Phelps for the people.
Sworn green on behalf of Ms. Hall. Ms. Hall, could you state your name for the court?
Renee Hall.
Thank you.
Your Honor, we're requesting an adjournment of this matter. We provided some documentation to the people. I'm asking for an adjournment to give them a chance to review that.
Tyranny, before you leave. What?
I'm asking for an adjournment so they can review the documentation we provided the people, Your Honor.
December 12th or December 11th, excuse me, 2025.
Thank you.
9 a.m. bound continue. Court calls the case People versus Carol Hollins.
Senator Water, Assistant Prosecuting Attorney for the people.
Assistant Public Defender Sandra White on behalf of Carol Hollins. Just a second.
Well, you can stay up here with her if you're going to take her back. That's fine. Yeah.
Oh, okay.
Your name?
Carol Hollins.
All right, very good. All right, what are we doing?
Your Honor, it should be a plea form. Present.
When did it come in?
I sent it to you. You can decide to submit it.
Okay, Your Honor, can we adjourn a short adjournment? My fault.
Is it?
My fault, Your Honor.
Miss Hollins says she doesn't want to come back.
Okay.
She said she hates me. I mean, I could hear.
Yeah, TV.
Yeah.
I love you, smart.
Thank you, ma'am. Is it a guilty? Or
Yes, Your Honor. I'm gonna pass it. I can.
Pardon?
If you want to pass it, otherwise we can have the fourth. I can get it over here.
What is she talking about? I was gonna pass it because Miss Hollins said she didn't want to come back.
Okay, we can pass it, Your Honor.
Fine.
Thank you, Your Honor.
All right. So when I get the paperwork, I'll take, and we'll try to get it done today for
Okay. We're back?
Yes.
Okay.
you. Court calls the case People versus Nathaniel Jones, the second.
Ashley Phelps for the people.
Even if she's in the room, it takes forever.
I don't know
It's-
how this happens.
I don't know
every
how it
time.
happens either. Your name, sir?
Nathaniel Jones.
Thank you.
I was here. I was here. It's right there.
Er,
Judge, we're asking
yes.
for a very brief adjournment. I think that we are almost there.
Probable cause conference, December 4th, 2025, 9 a.m. Bond will continue.
Thank you, Judge.
Thank you. We're almost there. Court calls the case of the People versus Sandra Leonard.
Overwater Assistant Prosecuting Attorney for the People.
Assistant Public Defender Chelsea Vergils with and on behalf of Sandra Leonard, who appears via Zoom. Ms. Leonard, please state your name.
Sandra Leonard.
I have before me a plea form. Is that what we're doing?
Yes, Your Honor.
Plea form indicates the defendant will be pleading guilty to the charge of retail fraud, second degree, the 1-year offense. Upon her successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
That's correct, Your Honor.
That's correct, Your Honor.
Ma'am, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth? Oh, I just muted her. I'm sorry. Your testimony will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
State your name again, please.
Sandra Leonard.
All right. Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of retail fraud, second degree. That's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes, sir.
Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
You understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form or had one signed on your behalf?
Yes.
You have any question regarding any of those rights?
No, sir.
You understand that you're giving up all the rights, particularly the rights contained in paragraph 5, which are your trial rights.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir, I do.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily?
I am.
Of your own free will?
Yes, sir.
And because you believe that you are indeed guilty of this offense?
Yes, sir.
I just find my seriously. Don't understand where my plane is in this. That's all right. Sit down. Thank you. Between the dates of June 6, 2024 and December 9, 2024, at the location of 771 Airport Boulevard, that being the Costco, what'd you do that makes you think that you're guilty?
I took merchandise without paying for it.
Okay, so you went in on numerous occasions, took merchandise and walked out without paying for it?
Yes, sir.
And was the total amount that you took without paying for it, was that in excess of $200?
Yes, sir.
Was the store open to the public at the time when you did this? On
Yes,
these
it was.
occasions?
Yes, sir, it was.
And you didn't have anybody's permission to take that property, did you?
I did not know.
And the property you took was property that was offered for sale by Costco?
Yes, sir.
Ma'am, I do have to advise you, if between the time of me accepting your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rule, you would not, the court would no longer be bound by any sentence recommendation and or evaluation, and you would not be entitled to withdraw your plea. You understand that?
I do, sir.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
People are not.
No, Your Honor.
And have I complied with the court rule?
People are satisfied, Your Honor.
Defense is satisfied.
Court will accept the defendant's plea to count 2. Count 1 will be dismissed. A pre-sentence investigation and report is ordered at 14A1. Probation sentencing in this matter will be
December 22nd at 9 a.m.
December 22nd, 2025, 9 a.m. That is before me. Bond will continue.
Your Honor, can I address a bond condition, please?
Sure.
When Miss Leonard made a travel request, which was granted, she was ordered to pick up a SoberLink device. She had been weekly ETG testing. She's returned from her trip. From what I understand, there were no positive tests. We're asking to return the SoberLink device and switch back to weekly ETG testing.
She took the SoberLink with her on her travels,
That's correct.
and she wants to go back to the ETG testing. Is there a problem for that? I'm not gonna have a problem with that if we could prepare an order to that effect, and we'll get that over there.
Thank you, Your Honor.
Thank you. Thank you, ma'am.
Thank you, sir.
Court calls case, People versus James Miller.
Thank you, Your Honor. Alex Warren Green on behalf of Mr. Miller. Mr. Miller, could you state your name before, please?
James Miller. Thank you.
Your Honor, I'm asking to adjourn this matter. We need to complete media discovery in this case.
How long did you need?
I'd defer to the people on that. We just need media discovery, Your Honor.
December 11th, 2025, 9 a.m. Bond will continue to give you time to heal. You're welcome. Thank you, sir. Court calls the case, People versus Mark Montgomery.
Ashley Phelps for the people.
He's a passenger.
Brian Bowling on behalf of Mr. Montgomery, Your Honor, who should be on Zoom.
He is.
And he indicates to me he is not driving that vehicle, Judge. He is a passenger.
Okay. They need new shocks. Anyway.
Mr. Montgomery, can you state your name for the record, please?
Great. I can't hear you. Still can't. Oh, no.
Edward Montgomery Jr.
Thank you.
Judge, I'm asking for an adjournment in this matter. Plea offers not being made to Mr. Montgomery at this point in time, so I need to have a little further discussion with him about his options of moving forward and what exactly he'd like to do with the case.
Probable cause conference will be adjourned December 11th, 2025, 9 a.m.
Thanks, Judge.
Court calls case, People versus Samuel Peoples.
Ashley Phelps for the people and all 3 matters.
Brian Bowling on behalf of Mr. Peoples in all matters, Your Honor. He and his mother are sitting in a conference room right out there. He was on Zoom with 14A2. I believe his case was just called in that courthouse. I can go check
bench warrant
if you'd like me to. Well, that's up to you, but I don't think
I know it is. Thank you. Thank you for acknowledging that.
You're welcome, Jeff.
And so because you acknowledge that, I'm not going to do it.
Thanks, Judge.
All right, I'll pass.
Thank you.
See, that's how you be nice to the judge, Miss Acker. Court calls the case, People versus Ramon Raymond.
Assistant Public Defender Sandra Wright on behalf of Ramon Raymond.
Oh, there he is.
Ramon
Sir,
Raymond.
can you state your name? Thank you.
Ramon Raymond.
Your Honor, I have started negotiations with the prosecutor. There's some information she would like from me, so I'm asking for an adjournment.
Got a green sheet?
I do.
Do you?
Yes, back there.
So why is everybody learning from making ruling? No, I'll adjourn it. Probable cause conference, December 11th, 2025, 9 a.m. Oh, but at least yours is filled out.
Yes, it is.
So it's not like Akron.
Thank you.
Okay, and can I say something, Judge? I'm sorry. It's nothing against you or the public defenders. This is the first time I got in touch with. I've been trying to reach out to my public defenders and everything, and me, my wife, everything. Been trying to reach out to them. I haven't talked to nobody.
You haven't,
Raymond, we
Hold
have
on.
been talking by
Last
text,
night, last night
by
was the
phone.
last night
Okay,
was
Mr. Raymond.
and last night was the first time I talked to her, and
Talk to,
like
say
on
again,
phone. Last
say
night
that
was the
last part
first.
again.
Last night was the first time I talked to her on the actual phone. I've been reaching out on text and I've been calling her, leaving her voicemails. My wife been calling her. Yeah, she texted my wife, but and when I say this, I'm not trying to be mean or asshole, but this is my life on the line.
No, I hear you. I hear you.
I'm trying to I haven't heard from nobody. She told me, they called me and told me that I was gonna have another, or she texted me and told me I was gonna have another or attorney. I'm trying to figure out what's going on.
Your Honor, may we
Well-
approach?
Yeah. Man. Hang on a second, sir.
All right.
My bad. I'm good. Okay. All right. Sir, I've adjourned it out to the 11th. I would just indicate to you, and I think council would say on the record that there were numerous texts that came in, but the case may not have been assigned to her for that week or that period in time, which might delay a response. But I think the other thing that you have to be aware of, and anybody being or having representation of counsel, they're not sitting in your office able to always respond. If she were sitting in court on the record before me, she couldn't respond. So
That is correct.
I'll just leave it at that, but I've not known them not to try to reach out to respond to someone. So I'm sure
Yes,
they
sir.
will
Yes, sir.
try to
No,
deal with that. Oh,
I understand that. I understand that. And I'm trying to get it going. And I'm
no,
trying to take.
I understand that, but you also need to also understand, you said one thing, and I just want to clarify that because I think we're both from the prosecutor standpoint and the defense side, extremely blessed in this county to have the attorneys working on both sides of these cases. And if for whatever reason you think there's ever a given moment that any of the attorneys, certainly on the public defender side, but also on the people's side, that don't realize that it's your life at stake, then, sir, the only thing I can tell you, sir, is you're wrong. You're just wrong on that. They get it. It's just a matter of being able to get to you when they can get to you with information and make it a fruitful conversation. So I'm going to leave it there because I usually am not involved in those things. I'm sure that they'll get in touch with you and there'll be other work through this case. So I'm adjourning it to December 11th, 2025, 9 a.m. Bond will continue. Thank you.
Thank you.
All right. I appreciate it. Thank you.
Court calls the case, People versus Jesse Rogers.
Cash Feltes for the people.
Michael Gaddy, Assistant Public Defender on behalf of Ms. Rogers, Your Honor. Your Honor, Ms. Rogers, I've been in, as much as I hate it, text communication with her all morning. She is on her way. She forgot her wallet and turned back. I'd ask the
To
court.
where?
She lives in New Boston. So she's on her way to court now as of 6 minutes
Notice
ago.
how
She said she was
Daddy,
19.
He said New Boston. He did a little New England accent. Did you notice that?
She's coming from New Boston, Your Honor. Bringing chowder. I asked the court to pass this or issue a show cause.
Fine. You know, so the file went up. I was going over there. It almost flew that way. I'll pass it.
Thank you, Your Honor.
Because he does that to me all the time. He just likes to irritate me. Court calls the case, People versus Aaron Davis.
Kenneth Overwater, Assistant Prosecuting Attorney for the People.
That's Bishop.
Christopher Quinn appearing on behalf of Mr. Davis.
Aaron Davis.
I have before me a plea form now that indicates that the defendant is going to be pleading to an added count to a false pretense as 200 to 1,000. The 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. Also, there's a sentence agreement of a sentence under the Homes Useful Training Act. That's the court's full understanding of the plea agreement. I need him to check the box regarding the sentencing judge waiver and making sure the client understands all of that. May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm to the right hand? Solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
Aaron Davis.
Sir, it is this court's understanding that you are going to be pleading guilty to the charge false pretense is 200 to 1,000. That's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. Court further has to advise you that the fine could be increased to 3 times the value of the property taken or involved in the false pretenses. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
Yes.
Yes. You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A3 District Court.
Yes.
Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
And you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct? Any questions regarding any of those rights?
No.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will? And because you believe that you are indeed guilty of this offense?
Yes.
October 11th, 2025, 1610 South Main Street, City of Chelsea, Washtenaw County, State of Michigan. What'd you do that makes you think that you're guilty?
So what did I do?
Yes.
Oh, walking into a store with counterfeit money.
Okay, you tried to pay for items with counterfeit money? Yes?
Yes.
You knew it was counterfeit? Was the amount of either the items you obtained or the amount of counterfeit money that you intended to pass, was it in excess of $200?
I think it probably was like 220, but a little over.
You said 220?
Like $220.
Is that more than $200? Okay. And you intended to deceive the people receiving the counterfeit that they were receiving real money in exchange for other goods or services. Is that correct? Sir, I do have to advise you that if I accept your plea, if between the time of your plea and the time of sentence, if you commit misconduct as defined by the Michigan court rules, the judge would no longer be bound by any sentence evaluation or recommendation, and you would not be entitled to withdraw your plea. You understand that?
Yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Judge.
And has the court complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Judge.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A3 probation. Sentencing will be
January 5th at 9 a.m.
January 5th, 2026, 9 a.m. before Judge Freshour. Bond will continue. Thank you. Thank you. Court does call the case People versus Carol Holland. This is also
Prosecuting Attorney for the People.
Assistant Public Defender Sandra White on behalf, again, Carol Holland.
Hello there again.
hello. State your name.
Carol Holland.
All right. I have before me now a plea form that indicates that Ms. Hollins will be pleading guilty to the charge to an added count 3 of use of a controlled substance, a 1-year offense. Upon her successful plea to that charge, count 1 and 2 would be dismissed. That's the court's full understanding of the agreement.
That is correct.
That's correct.
And I have her sworn.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name, please.
Carol Hollins.
All right. Ma'am, it is this court's understanding that you're going to plead guilty to the charge of use of a controlled substance. That's a misdemeanor punishable by up to 1 year incarceration and $2,000 fine court costs. Do you understand that?
Yes, I do.
You understand also, ma'am, while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 1484 District Court.
Yes, I do.
All right.
I wish you would be though.
Pardon?
I wish you would be though.
She wants you to be her judge.
Doesn't everybody? Just kidding. Thank you for saying that, ma'am. But this case it goes to Judge Freshour. But do you still wish to plead guilty, ma'am?
Yes,
And to that charge, how do you plead?
guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
I understand.
You signed an advice of rights form, is that correct?
Oh, yes.
Any question regarding any of those rights?
No.
You understand that you'll be giving up those rights as well as all the rights contained on that form, is particularly the rights contained in paragraph 5, which are your trial rights. You understand that?
Yes, I understand.
You understand you're giving up your right to appeal of right.
I understand.
Are you on probation or parole?
No,
Has anybody promised you anything other than
No.
what's been stated here today? Anybody threaten you or coerce you?
no,
You're doing this voluntarily
yes,
of your own free will
yes,
and because you believe that you're indeed guilty of this offense?
oh, yes,
On the date of June 6, 2025, at the location of 701 Main Street, Manchester Township, Washtenaw County, State of Michigan, did you have cocaine in your possession?
yes,
Had you used it?
yes,
Did you know what you were using was cocaine?
yes,
All right. Ma'am, I do have to advise you that if I accept your plea, if you commit misconduct between the time of my acceptance of your plea and the time of sentencing, the court would no longer be bound by any sentence evaluation and or recommendation, and you would not be entitled to withdraw your plea. You understand
I
that?
understand.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor, I am not.
And have I complied with the court rule and would it be proper to accept this defendant's plea?
People are satisfied.
Satisfied, Your Honor.
Court will accept the defendant's plea to count 3. Counts 1 and 2 are dismissed. A pre-sentence investigation and report is ordered at 1484 probation. Sentencing in this matter will be
January 13th at 9 a.m.
January 13th, 2026, 9 a.m. before Judge Freshour. Bond will continue. Thank you. Thank you.
Thanks for your time, Your Honor.
Not a problem. Have a blessed holiday, please.
Yes, you too.
Court does call the case of the people versus Daniel Simon.
Ashley Lonnie Feltus for the people.
Brian Bowling on behalf of Mr. Simon, Judge. Daniel, can you state your name for the record, please?
Daniel Simon.
Judge, I'm asking for an adjournment in this matter. Mr. Simon picked up discovery from our office on Friday. He had a little bit of a technical issue with being able to watch the videos, so I just want to give him a little more time so he can.
Got it. Probable cause conference will be adjourned to December 11th, 2025, 9 a.m. Bond will continue. Thank you, sir. Court calls case people versus Brandon Sims.
Lawyer, Assistant Prosecuting Attorney.
Assistant Public Defender Dottie Lebo on behalf of Mr. Sims is approaching. Mr. Sims, can you state your name, sir?
Brandon Sims.
Your Honor, we're still in plea negotiation. I did have a conversation with Mr. Overwater earlier regarding that, and I'd be requesting an adjournment.
Probable cause conference, December 4th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
Thank you, sir. Court calls case People versus Derek Smith.
Yes, that's defendant. Assistant Public Defender to not be carried out orderly on behalf of Mr. Derek Smith. He should be on Zoom, Judge.
He is. Mr. Smith, can you state your name, please?
Derek Smith.
Thank you.
Judge, we're requesting an adjournment for further investigation.
Probable cause conference, December 11th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Thank you, sir.
Thank you. Give me a call.
Court calls the case People versus Danielle Stewart.
Mike Getty, Assistant Public Defender, on behalf of Ms. Stewart, who should be here by Zoom, Judge.
Yep, she's.
Here, hi,
Hello, state your name.
Danielle Stewart.
All right.
Your Honor, we're requesting a brief adjournment. The people have made an offer, and I would like to go over that offer with Ms. Smith.
All right. Probable
Stewart,
cause
sorry.
conference will be adjourned December 4th, 2025, 9 a.m. Bond continued.
Thank you, Judge.
Thank you.
Okay,
Thank you, Ms. Stewart.
Thank you. Have a good day.
You do the same. Court calls case People versus Justin Straight.
Prosecuting Attorney Vikky.
Assistant Public Defender Chelsea Vergils with and on behalf of Justin Straight.
Justin Straight.
And we're requesting a brief adjournment. There was an offer recently made. We'd just like some time to consider that.
Probable cause conference, December 4th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court calls case People versus Raven Strasser.
Assistant People.
Assistant Public Defender to not be carried out orderly on behalf of Mr. Raymond Strasser, who is approaching Judge.
Oh, your name, sir?
Pardon?
Your name?
My name is Raymond Strasser.
Thank you.
Your Honor, we're asking for an adjournment in this matter. I think we've sent over a referral to Veterans Court.
It's to Vets Court.
That is what my note says, yes.
I saw the referral just now. You're a veteran, sir?
Yes, sir.
Which branch?
Army.
Okay. I guess I'd like them.
Pardon?
I said, I guess I like them.
Oh, okay.
All right.
I volunteered.
Did you? How long you served?
I served almost 3 years.
3 years.
I got wounded,
Oh,
but that's okay.
Well,
I'm alive and I'm
There you
71 now.
beautiful.
So
where were you?
Vietnam.
Damn. Okay. Well, God bless you. Thank you for your service.
You're welcome.
As I say to vets, and I hope it means something, I realize I did not have to go.
I know.
And so I will just say that I get to do what I get to do every day because people did what you did. So I'm always appreciative.
Well, I do have something to say.
Yes, sir.
This is the most interesting courtroom I have ever seen.
I think that every day.
I know I've been here a few times on Zoom and here, but yeah, it's always interesting. I learn more than I ever thought I would.
That's me, the great teacher. Right? Why'd you look like that? I can really, seriously?
I agree, Judge.
No, you didn't. Did you see her face? You see how she's good? Great teacher. You don't do all that.
I understand there's some papers. Fine.
Yeah, we'll get all that too.
Okay.
Don't worry.
Probable cause conference. Why don't I put this out? Do you know how quickly they're running for an assessment on that?
I don't. I know mental health court has been going pretty quickly, though.
Yeah. So why don't I do this? Let me.
Your Honor.
Yeah.
With the holiday approaching, I've given at least 2 weeks for Miss Finney, so she said.
Got it. All right. So why don't I do the 18th?
Okay.
December 18th. 2025, 9 a.m.
What, back here?
Yes, sir.
Can I do it on Zoom?
If they submit the forms, then I
Yeah,
will
okay.
strongly,
Yeah,
I'll
'cause I'm
strongly
moving into a new
consider it.
apartment today.
Pardon?
I'm supposed to move into a new apartment today.
Are you? Okay. Well, he wants to sit in his apartment.
That's
All right, that's fine. If they submit the form, then we'll
Okay.
strongly consider it. Thank you.
I will, no, not to sign right now.
Okay.
Court does call the case People versus Brenton Warren.
The water assistant prosecuting attorney for the people.
Michael Getty, defender on behalf of Mr. Warren, Your Honor.
Like it's, I don't want to show cause.
Your Honor, I was in touch with Mr. Warren yesterday. He actually sent me some documentation about the medication. A printout and a letter from, or a notation from his doctor at U of M. I don't have any explanation as to where
Bless you.
I've texted him, bless you, I've called him. I don't know. I'd ask the court for an adjournment.
Bench warrant will issue for defendant's failure. 10,000 cash surety that will issue immediately.
Thank you. Man.
For calls case People versus Tierra Williams.
The water assistant prosecuting attorney for the people.
Assistant Public Defender Donnie Lebo for Ms. Williams. Ms. Williams, please say your name, ma'am.
Tia Williams.
Thank you.
And Your Honor, I was just able to make contact with Ms. Williams today. I do now have good contact information for her. I'd be requesting an adjournment, please.
Probable cause conference, December 11th, 2025, 9 a.m. bound continue.
Thank you, Your Honor.
Court calls case People versus Damian Williamson.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Williamson, is making his way to the podium, Judge.
Your name?
Damian Williams.
Your Honor, we'd ask the court to set an exam.
All discovery is complete.
To the best of my knowledge, Judge.
You will have the witnesses available tonight.
This is Mr. Williamson, correct?
Yes.
Yes, sir.
Okay, I think I had Williamson one spot. We will try for that date. Thank you.
Preliminary examination in person will be set December 9th, 2025, 9 a.m. before Judge Washington. Bond will continue. Thank you.
Thank you.
Thank you, Your Honor.
Court does call the case of People versus Anthony Wilson.
Office for the people.
Come on through, sir. Just push them out of the way. I'll tell you how to read it.
There's two courts going on. Right? Okay, Your Honor. Assistant Public Defender Chinazi K. Your Honor, on behalf of Anthony Wilson.
Your name, sir.
Anthony Wilson.
Thank you.
Your Honor, I just want to confirm the note, but Mr. Wilson indicates that he and Mr. Warren Green intended to set this matter for preliminary examination.
That's fine, except that I have violation report.
Dated yesterday, Your Honor.
Yes, ma'am.
And he got the email.
Where he's not gone over to, he's missed 3 tests at community correction.
So I don't stay out here. I've been testing in Detroit, Michigan. So
Well, there's a way to do that, but this is not the way, because I don't know anything about any testing in Detroit.
Trying to pull up the information, Judge.
Yes, ma'am.
he got the information.
Where are my lawyers?
Okay. Well, then, Your Honor, can we pass this matter? He indicates that he's already given some information to the court.
To who?
Mr. Warren Green, Alex.
This man. He's saying he gave it to Warren Green?
Yep, so.
Where is Mr. Warren Green?
Judge, he's next door.
Can you forward it to you or what?
That's fine. Your Honor, it looks like what he's showing me are drug test results from ADCS lab. Obviously I'll need to, can you send it to me?
To do what?
I just wanted to look at the results that he's showing me, Your Honor. It looks like he did, this test was dated 11/11. Well, no, 11/9.
Yeah, they both are.
Okay.
There's another one right up under it.
And then there's another collection that was dated on 11/7.
Who's he doing that testing for?
It's A as in apple, D as in Daniel.
I get it, but why is he testing?
It's supposed to be for cocaine.
Pardon?
Who's telling you the test? Are you calling him to the correction? When you number stuff, you go to test?
They gave me a new color. Like, once I went to the place, they gave me an actual color that I called instead of that number.
Who gave you a color?
The location where I go to do my dropping.
Okay, but why are you testing at that location?
Because I'm from Detroit. I don't stay out here. I've never been out here until I encountered with this case. I had this situation. So the agent that's over this, whatever, she gave me an address and a couple addresses in Detroit where I could go do.
She told you to test there. Did you sign the release?
Yeah, they have all my information.
What was her name?
What is
Your Honor, may I?
Go ahead.
Thank you, Your Honor. Alex Warren Green on behalf of Mr. Wilson. Your Honor, I spoke with Mr. Wilson about the missed samples reported by Community Corrections here. He provided me screening results from ADCS lab in Detroit. When I spoke with Mr. Wilson last night, I told him he needs to make sure that those results are being reported directly to Community Corrections. If I could show the people briefly and approach the court with these results. He did submit to testing there on.
Can you find out if they referred him over there? Because he's telling me that Community Corrections sent him there.
They did.
All I can see, Your Honor, in the report is it says local testing in Detroit permitted. I don't know if they gave him a specific.
In what?
In the bond violation report. It definitely doesn't specify ADCS lab on McNichols, but I guess.
Did he sign a release? I guess I'm trying to figure out why these results aren't getting here.
My suspicion is he did not sign the appropriate releases.
I signed all the paperwork they gave me. I don't know. If you want to take the number, you can call them and figure out what's going on.
Mm-hmm.
You have those papered?
I do, Your Honor.
Have the people
No, I
seen?
have not.
How many tests are we looking at?
There's two tests, Your Honor, that I'm looking at now. There's a test from 11/7 that was collected and 11/9.
And are they negative?
No, they're positive for THC.
That's correct, Your Honor. So with Community Corrections reporting misses on November 7th, November 12th, and November 17th, it seems like the position we're in with what we have is that he has probably one true miss at this point, along with the positive THC results. And I told Mr. Wilson if he is using marijuana for.
Does he have a card?
I told Mr. Wilson he would need to get a medical marijuana card if he wanted to use it for medical reasons.
He doesn't have a card he's on bond. Can't do it.
The other
Understood,
issue,
Your
Your Honor, is
Honor.
that the most recent test was 16 days ago.
That's not true.
What's not true?
9th was the most recent test.
No, it just went on, I think Saturday. It was either Friday.
When?
Based on the paperwork I have, it's been 16 days.
It's either Friday or Saturday.
Where's that test result?
This is what they emailed me this morning, like literally.
Your Honor, what I would note is that the two results that we do have, the date collected and the test date are in one case 4 days apart and in one case 2 days apart. So I don't know if they have a delay in getting the results from their testing. I am not familiar with this agency at all, ADCS Lab.
Why is he still using marijuana?
Your Honor, I spoke to Mr. Wilson and he tells me he has been a marijuana user for a long time. I told him he needs to ensure he has a medical cannabis license if he is going.
When he doesn't have one.
I was using prior to this
Not at
case.
this time, but Mr.
I should
Wilson,
already had positive marijuana results the first time I went.
hold on. Mr. Wilson assures me he will take the steps he needs to get licensed to use marijuana if he
But he could have been doing that from the beginning of this case,
understood. Your
but he hasn't done it.
Honor. Your Honor, my request.
Well, here's what we're gonna do. We're gonna take him back. You call the place. If he tested, you said he went yesterday?
When did you
I
went?
can give you the number. You can call.
You said Friday or Saturday. Is that
Yeah,
correct?
literally.
Okay.
I just called them because they had to send an email this morning. I literally just got off the phone with them. Here go the hours right here too. Like, okay.
Just give me the number. I'll get in touch with
This is crazy.
I just need some confirmation that he indeed tested.
That's the hours.
And I'm gonna decide what to do with it.
So what does that say? Yes,
Your Honor, I
Saturday at
appreciate the
7:30 in the morning. That's when I was just there.
I appreciate the court's consideration, Your Honor. I'll speak with the lab and I'll speak with my client.
You can take him back.
I gotta give them the number to the place.
I got it.
No, that's not the number. Here, the number's right here in my messages. Like,
Oh,
you don't have it because it's right here. It's 313. Here, take the number. Okay, yeah, you got the number to the place. 552-3335.
thank you. I'll come back and talk to you in a second.
Probably that you got.
Damn. Grab it.
I think you better cooperate. I just need clarification. This one. Court calls the case People versus Robert Watkins.
Ashley Feltus for the people. That's Mr. Warren Green's case, Your Honor. I will say,
Well, I will adjourn it because
yes,
the facility did not sign in.
we didn't
You
have.
got
time
that,
to
Akin
correct.
Ruley?
I did, Your Honor, Assistant Public Defender Tanazi
You gonna be able to communicate that to Mr. Warren
I
Green?
absolutely will.
You
let him know
sure?
that. Yes, Judge.
Mr. Gaddy, make sure it happens.
Could we get the 11th date? Do we have enough time for the rip, please?
Because we'll be adjourned December 11th, 2025, 9 a.m. Bond continued. Those are all interpreters. I don't know who I've got left. I don't either. I don't know. They were telling me to pass them. Bowling is at the bottom of all of this mess. Two of them were yours? How do you get that?
You were gracious enough to do so.
I don't even like him that much. How did, he was giving me some sad story. You do like that, right? All right, well, I'm just gonna call him.
You ready for the recalls?
Yeah, we're
Oh,
ready.
okay, we're ready.
Court calls the case People versus Jesse Rogers.
Ashley Feltus for the people.
I don't know, is that?
That's Gaddy.
Michael Gaddy, Assistant Public Defender on behalf of Roger.
How's that looking, Mike?
Your Honor, the last word I had was at 11:10, said they'll be there in a second. So I assume she's not. I'd ask the-
Okay, I saw community corrections. I got nervous. She doesn't have a violation.
She'll be here any second?
That's what, that's the last.
Fine.
Thank you, Judge.
I'd like to say you're welcome. I know. All right, who's ready on Peoples?
Okay.
Who's that for?
Well, this is the one you passed because he needed to get here because we didn't have the violation report. So.
It's gotta be one of those two. Court calls the cases of the People versus Samuel People.
That's calls for the people.
Brian Bowling on behalf of Mr. People, the approaching judge. State your name, please.
Sam.
Your Honor, we're here for competency evaluation or competency hearing. The Public Defender's Office did receive the report from the Center for Forensic Psychiatry yesterday afternoon. I reviewed that. The finding was incompetent but restorable. I would stipulate to the contents of that report.
Counsel, approach, please. Record should reflect we've had a rather lengthy bench conference. Did your client state his name?
State your name again, please.
Yep. Samuel Peoples.
Thank you. All right, so what I'm gonna do is this, based upon the report, the court will find that at this time, the defendant is incompetent to stand trial, but restorable. And I will sign orders to that effect in all three of these matters. He also has a bond violation. I looked at the bond violation. The part of the issue is going to be, and even trying to admit to that given the current circumstances, but also then in terms of what the court wants to do. So I'm going to set a review on the bond violation. I'm going to set that for January 8th, 2026 at 3 p.m. And then a competency review hearing will be set for February 26, 2026 at 9 a.m.
Perfect. Thank you.
Got it? Okay. And at this time, his bond will continue. Thank you, Mr. Seed.
I'll talk to you in a minute, okay? A minute.
Court does call the case People versus Larry Atkins.
That's the calls for the people.
That's the one I had to find.
Brian Bowling on behalf of Mr. Atkins, who's approaching judge.
Oh, yeah. All right. Where are we?
Judge, state your name again for the record.
Larry Atkins.
I got it right.
He did that time. Your Honor, thank you for passing this matter. After speaking to Mr. Atkins, I think he understands a little bit more of what this court was exactly looking for him as purpose of the factual basis for the plea. We discussed the facts and circumstances of the case, and he would like to move forward with the conclusion of his guilty plea today as originally planned. I believe Mr. Atkins will be able to provide a valid factual basis for that plea, and we'd ask the court to resume with the process.
All right. So we were on attempting to try to get a factual basis. You had at some point called the police regarding withdrawals from your account.
Yes,
Is that correct?
that's correct.
All right. At the time that you called the police, you indicated your condition, but at the time that you called the police, did you know that those allegations that you were making regarding missing money were untrue?
Yes,
You did? And you continued on with that process with the police, knowing it to be untrue, correct?
correct.
Mr. Atkins, if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules between now and that time, that court would not be bound by any further recommendation or evaluation, and you would not be entitled to withdraw your plea. You understand that, sir?
Yes.
All right. Counsel, are you aware of any other promises, threats, or other inducements that have led to this plea?
No, Your Honor.
Neither am I, Judge.
And have I complied with the court rule? Would it be proper to accept this defendant's plea?
People are satisfied.
I agree.
Court will accept the defendant's plea of guilty count two, count one is dismissed. Pre-sentence investigation and report. It's ordered at 14B probation. Sentencing in this matter will be
January 15th at 10 a.m.
January 15th, 2026, 10 a.m. That is before Judge Washington.
Thank you, Your Honor.
Bond will continue.
Thank you, Your Honor.
Thank you, Your Honor.
You like to be alive, man. No, Mr. Higgins, take care. Have a good holiday.
May Ms. Feltus and I approach on a separate matter?
You may.
Thanks.
Wow. When we're. What's this one?
That was a recall because the defendant wasn't here, but they're here now.
This is Mr. Gaddy's? Nope.
That's your own answer.
Yeah, okay, never mind. Court recalls the case people versus Jesse Rogers. That's pretty much how it is with Mr. Gaddy.
Michael Gaddy for the Assistant Public Defender for Ms. Rogers, Your Honor. And when I'm the only option, I like those odds.
Your name, ma'am?
Jesse Rogers.
Your Honor, this matter has been adjourned. Ms. Rogers was going to retain John Shea's firm. That hasn't happened. I've reviewed the police reports and the video or the police reports and the various search warrants and other things. It's a pretty detailed case. I'd ask, it looks like my office will continue to represent her. I'd ask the court for a brief adjournment so I can go over all this evidence with her in a more detailed manner.
There is quite a bit.
All right. Will the 11th be enough time for you to?
Yes.
Grant that request, I'll adjourn it. Sir, do you have any reason to dispute those blood test results?
No.
And had you previously been convicted of operating while intoxicated either on March 26, 1996 or on February 13th, 2002 in the South Carolina District Court?
Yes.
Sir, if I accept your plea, between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rule, the court would no longer be bound by any sentence evaluation and or recommendation, and you would not be permitted to withdraw your plea. You understand that, sir?
Yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, sir.
No, Your Honor.
And have I complied with the court rule?
Yes.
Satisfied, Your Honor.
Court will accept the defendant's plea of guilty to count two. Count one is dismissed. Pre-sentence investigation and screening and assessment is ordered at 14A2. Sentencing in this matter will be
December 9th at 10 a.m.
December 9th, 2025, 9 a.m. That's before Judge Barr.
Your Honor, I would like to address bond, and I was wondering if I may approach on one piece of it with the prosecutor.
You may. Where's she going? Oh, she came in. See, this is what happens when you get in leadership. You go in, I'm gonna do a couple cases, then I'm out. Take care. Yes, and to you. Go ahead.
So, Your Honor, my client is being held on revoked bond. He is requesting for his release today. Obviously, he has pled guilty to the charge and taken responsibility for his the behavior. He, as I say at the bench, does have custody or guardianship of his daughter's 6 children. He is requesting that the court release him so he can be home with those kids during Thanksgiving. When we talked about his bond, he says he wants to teach his grandson how to fry a turkey this week. He is willing to comply with any bond conditions the court may order. He's requesting a second chance. He does receive disability, and does work a couple hours a week to keep that disability at a local church in Ypsi. He wants to get out, commit to his sobriety and take care of these grandchildren with his wife.
So anything from the people?
Your Honor, I'm recommending one of those handheld blow-in devices that I believe we call it locally SoberLink. You'll recall the defendant's violation that has him in custody. He provided some sort of explanation where he admitted to tampering with the wearable alcohol monitor. Mentioned something about the cleaning supplies at his work having an atmospheric effect on the GPS, or, excuse me, the monitor itself. And I think that if we're going to let him out, I would not be opposed, and I'd be recommending the blow and go monitors. Nothing.
How am I gonna keep you from drinking?
I'll blow. I'll do whatever it takes. I'll blow in it. I'll do whatever it takes. I just want to be home. I get the counseling I need.
One thing I didn't add, Your Honor, is he is going to AA once a week from 7 to 9. So that is an added support there. His priors are he does have priors, but they are old. So I'd ask the court to take that into consideration as well.
And my AA is at my job every Thursday.
How old's the grandson you want to teach to fry a turkey?
He's 5, and I got 1, 2.
You're not gonna really be teaching them. They're gonna be sitting up there watching.
Well, I mean, they could be standing there, but not close to me, but not for the greasy.
Yeah,
jump
no,
on
I
me.
hear you.
Yeah.
I'm gonna reset the defendant's bond back to a $10,000 personal recognizance bond. How long have you been in? I put you in on the 20th.
Yes, his last PCC.
So you've been in about 4 days.
5 days.
5.
Yes.
Yes, I think so.
Here's what I'm gonna do. I usually don't go backwards, but maybe because what I will do is I will order a SoberLink testing device. I'll be blowing to that. That's 3 times a day.
Okay.
You understand that?
Sir.
And I need you to understand that if you miss a blow, that's as good as a bad blow. Understood?
Yes.
I'm also going to order an ETG random 1 time per week.
Okay.
So you're going to be on 2 types of testing, and we're going to be able to tell if you consumed any alcohol. Understand that?
Yes, sir. Yes, sir.
I will sentence the defendant to 5 on his bond violation, 5 days, credit 5 days for the bond violation.
You'll have to go to committee.
Understand that, sir?
Out today.
Anything else?
No, sir.
Nothing for me. Thank you, Your Honor.
Thank you.
Mr. Wilson, don't mess it up. You hear me?
Oh,
all right. She filled those out. She's very proud of me.
I'm very proud.
Court does call the case, People versus Timothy Lacey.
Good afternoon, Your Honor. Ashley Lundy, Feltus for the People.
Good afternoon, Your Honor. Robert Ellman, with and on behalf of Mr. Lacey, who is approaching. Mr. Lacey, please state your name for the record.
Good afternoon, Your Honor. Timothy Lacey.
Good afternoon. All right, record should reflect we had a bench conference or an in-chambers conference on this case. And I'm going to adjourn his preliminary examination in this matter at the people's request.
That's correct, Rob. I completed the green sheet for the file reflecting that the victim on the case had in the county today. I believe they were in Dearborn. Has been in good contact with Ann Arbor Police Department requesting the adjournment.
And just for purposes of the record, Your Honor, I know we discussed this in chambers. I would like to place my objection on the record, and I would like to address bond whenever appropriate.
Go ahead.
Thank you, Your Honor. Currently, Mr. Lacy's bond is, I believe, set at $150,000 with no 10% privilege. He is the father of 3 small children. He is a business owner. He also works part-time at Habitat for Humanity and was planning on enrolling in HVAC classes coming up at the beginning of the year here. He was taken into custody on October 15th, which by my count, if my math is correct, that's 41 days in custody. This adjournment is not at the request of the defendant and is through no fault of his own. And I would like to note that Mr. Lacy's mother is here today to support him, and that kind of goes to my bond request. I'd be requesting that he be released on house arrest to his mother's residence.
Where was he residing before?
Here in Ann Arbor.
No, it's in Ypsilanti.
It's an address in Ypsilanti, Your Honor, with his child's mother, or one of his children's mother.
In response to the bond motion from the people.
Your Honor, I believe the court is familiar with Mr. Lacy and the criminal history that I put on the record before that I was concerned about, specifically his prior juvenile adjudication for assault with intent to rob while armed. I would ask that the court continue to bond as currently set. I do believe that during our chambers conference, we contemplated as fast a date as possible, being December 8th, in recognition of him being in custody. If his custody status changes, we can readdress that if need be, but I would request the court continue it. I do think the bond is appropriately set given the circumstances of this case, as well as his criminal history.
And for the reasons as stated before, also, I do believe that the bond, at least at this juncture, is set appropriately and will decline and deny the defendant's motion to reduce bond. Having heard part of the argument, at least that counsel has put on record, let me just say this, and I think the people alluded to it. My next date would have normally been the 23rd of December. One of the reasons, as we were in back, we were going around trying to find a date much earlier that we could hear the case. And so therefore, that's why I'm going to set it for December 8th, 2025 at 1 p.m. before me. So moved up significantly from when it would have normally just been adjourned to. That was, as the people were indicated, in recognition that both defendants would be in custody absent the court's decision on the bond argument. So I will deny the motion. I'll continue to defend its bond at this time. All right.
Thank you, Your Honor.
Thank you.
Thank you.
And Your Honor, that's it for me today. I don't believe I'll be seeing you again this week, so please have a happy Thanksgiving.
I indeed, once I get to it, I'm going to have it. All right. Thank you, sir. You have a good Thanksgiving.
Thank you.
Yes. Ready for Jones? Court recalls case People versus Jones. She thought it was her. Okay. I will get to you. Trust me.
May it please the court, Your Honor. Good afternoon. My name is Adam Clements. I'm from Perkins Law Group. I appear on behalf of the defendant. State your name, please.
Jones. Thank you. All right. Also on this one, people are making the request as a co-defendant of the previous defendant for an adjournment for the reasons as stated. I will adjourn preliminary examination to December 8th, 2025 at 1 p.m. That's before me, and that Because Mr. Jones didn't hear it, that significantly moved up from when date would have been had I adjourned it, because I would have adjourned it to the 23rd, but I am fitting it someplace in my docket much earlier than that.
Understood, Your Honor. We appreciate that.
All right, and I had explained it. All right.
Yes.
Anything else, Counsel?
Of course, one. No, thank you.
All right, very good. This bond will continue at this time. Thank you. Thank you, Counsel. Have a good Thanksgiving.
Yes, Your Honor.
Court calls case People versus Mia Caruso. Call.
Assistant Public Defender Davy Lieb on behalf of Ms. Caruso.
State your name.
Mia Caruso, sir.
The first case I called up when I came to the second half of the docket.
My apologies, Your Honor.
Now she's darn near last. No, we all understand it's your fault. All right. I am.
As well as an advice of rights, Your Honor.
The plea form indicates that the defendant will be pleading guilty to an added count to a false report of a misdemeanor to 93-day offense. Upon her successful plea to that charge, count 1 would be dismissed. And it's also agreed that the prosecutor will be recommending sentencing under the Homes Useful Training Act.
Yes, Your Honor.
That's the court's full understanding of the agreement.
That's mine as well.
Yes, that's a complete recitation.
And have her sworn, please.
Raise your right hand. Do you solemnly swear to affirm the testimony about the truth, the whole truth, and nothing but the truth?
Yes.
State your name, please.
Mia Caruso.
And it is this court's understanding that you are going to be pleading guilty to the charge of false report of a misdemeanor. That itself is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. You understand that?
Yes, Your Honor.
You also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Yes, Your Honor.
Understanding all of that, do you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
And you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you're giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will,
Yes.
and because you believe that you are indeed guilty of this offense?
Yes.
February 2nd, 2025, at the location of 2680 International Drive, apartment 801A, Ypsilanti Township, Washtenaw County, State of Michigan. What'd you do that makes you think that you're guilty?
I had falsified some of the details in the reporting saying that it was stolen while it was getting warmed up for a gas station run.
Say again?
Your Honor, may I have what here?
I had
I wanted to-
falsified some of the details stating that the car was stolen while being warmed up for the gas station, and that's not like how it was stolen.
So it was your car?
A company's car,
Oh,
my possession.
it was a company car.
Correct.
Where you worked or formerly worked?
I was formerly working for that company.
Okay, and you had one of their cars.
Yeah.
And so where was the car when you made this report?
When the report was like initially made, I believe it was already crashed.
Okay, so let me get this right, young lady. You had a car, it was a company car, you crashed it.
Someone that I know that like technically they stole it, they crashed it, and I had reported that it was stolen while it was like waiting to be warmed up at the gas station, but in fact it was already like
Hey, hold on. So somebody you knew stole the vehicle, or at least drove it away without your permission.
correct.
They crashed it,
Correct.
but not so bad that it was undrivable.
It was. Yeah, it was flipped upside down.
It what?
It was flipped upside down. Ended up like getting flipped in the crash.
Okay, so then at some point you called the police because of that?
Yeah, like they had told me that like, hey, I accidentally crashed your vehicle. Can we like get this figured out? And I was like, okay. Let me come up there.
So
Figure out what's going on.
hold on. The police arrived at the crash scene, right? Or no?
I
Your Honor,
believe,
if I may, she was not present at the crash scene.
yeah, I wasn't at the crash.
Okay, so they called you or somehow got through to you and you needed to call the police.
When after like I got a call from like my friend saying that they crashed my vehicle, I came up there and I had reported that like the vehicle had been stolen. It had been stolen while it was being warmed up for the gas station. When in fact,
Okay, now the gas station falls in. I couldn't
Yeah.
figure out after
You're
the
like,
crash how it got to the gas station.
You're like,
So
yeah.
you told the police that the vehicle got stolen when you were warming it up at the gas station.
Correct.
That was incorrect and false, right?
Yeah.
And the very fact that, well, you knew how it was stolen, but you didn't disclose that to the police.
After I got brought in for an interview, is when I disclosed like the whole
But your
story.
initial report,
But yeah,
was not
correct.
that, correct? Okay. And in doing so, you were in telling them about the warming up of the car and then whatever, then you were intentionally misleading the police and that report was a false one. Is that correct?
Correct.
If I accept your plea, I need you to understand that if you commit misconduct between the time that I accept your plea and the time of sentencing, you commit misconduct as defined in the Michigan court rules, that any sentence evaluation or recommendation the court would no longer be bound by, and you would not be entitled to withdraw your plea. You understand that?
Correct.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None known to the defense, Your Honor.
No, Your Honor.
And have I complied with the court rule, and would it be proper to accept this defendant's?
Yes, Your
You are
Honor.
satisfied.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing will be
January 15th at 10 a.m.
January 15th, 2026, 10 a.m. That is before Judge Washington. For a bond. Why?
Like, why did I say it?
Why all of this?
I didn't know what to do in this situation, to be honest. Like, it was like from 3 to like 6 a.m. I was just like tired. Didn't know what was going on. First ever like crazy thing. Yeah.
How old are you?
20.
Is your dad with you?
Yes, sir.
What did he say about all this?
It was a dumb and crazy thing I got myself into.
Is that that's what your dad said? He just looked at you and said it's a dumb and crazy thing?
He was kind of like, what the heck were you thinking? Kind of like type of deal.
And when your dad asked you that, what were you thinking?
Same thing. I didn't know what to do in that state, in that situation. Yeah.
And he raised you better than that.
Did. He did, sir.
Are you in school?
Not anymore, sir. I used to be going to college for business.
And what happened?
With school,
Sure, let's start there.
I wanted to start focus on making money and saving up for stuff.
So when you said you were going to do that, just ask a question. What did Dad say?
Wasn't the biggest like supporter of me.
Hold on a
dropping out
second
of
before
college.
you start that statement. What did your dad tell you when you said, I'm not going to school, I'm going to go out and just make money?
He is normally really supportive. He has like his own like little opinions. Kind of gave me like a look more of like speaking anything.
Okay, so what was Dad telling you?
He was telling me kind of that I was making a bad decision
Yeah. And why do you think he was telling you that?
because I probably should have focused more on school. Because school can higher my chances of a lot.
I mean, although dad didn't say it, you know he wasn't happy when you made that decision, right?
Yeah.
So why were you trying to skirt around it? I'm a dad myself. I know he was not happy.
Yeah. I just thought like making money was like I don't know, a tried good decision. And I wasn't really like 100% on going for business. I was still kind of like mixed up and I didn't want to like get myself wrapped up in like tuition debt, and all that with
So
like,
let's see, you went to school, the whole world's in front of you. You can decide from anything. It's just a buffet of things, but gee, you couldn't decide. So I just didn't want to do that and I wanted to go out and try to make money.
yeah, that was kind of like my
So how's that working out for you?
not the best. I have been thinking about like getting back into college
Really?
or trade school. But it's just the step I gotta take to get back into.
What did your dad tell you to do?
What did he specifically tell me to do? He'd encourage.
What would, no, why, I don't know why you're stuttering whenever I ask you that. You know darn well what the man would tell you. What would he tell you to do?
He'd tell me
Because
to
if
go to
you don't want to tell me, I'll bring him up here and have him tell me.
He would tell me to go to college and get my.
Would he?
Yeah.
So let's see. You're just too grown to do that because you're all 20 now.
I wouldn't say I'm too grown. I need to figure stuff out a lot.
What do you need to figure out? You're 20. You figure nothing out. You know nothing.
Yeah, correct.
I know. I've had one of you. So when are we going back to school?
I was trying to go for like psychology, and so when I just don't want to be in debt my whole life. That's my
This is gonna
biggest
be
like.
one of the long daughter stories. Go ahead. What?
I just don't want to be in debt. Like that's my biggest like thought process is I don't want to be in debt for a while, or for like not ever, but like if I would rather have the choice to be in debt or not take debt, I'd rather not.
It's America.
Yeah.
I don't know
Yeah.
why. When are you going back to school?
Hopefully by next.
No. We're not doing hopefully.
February of next year,
Perhaps when you leave court today,
Or-
it might be
or
a
no,
good
leave
time
court
for you to look
today.
into that.
even more.
Can I just ask you this? Why wouldn't you just do what your dad may want you to do? Is there a reason?
Not necessarily. It's just I'm bad at starting stuff and sticking with it.
No, your dad came down and sat with you at the last year.
Yes. Each one of them.
Oh, I know. I was watching. And he just sat there very patiently while you were going to come up here before the court. I'm sure he had other things that he could do.
Almost everything.
But I watched that man and he never left his daughter's side. Right?
Correct.
But why can't you do something that would probably mean the world to that man?
Yeah. You are right.
What?
I said you are right. I do.
I know I'm right. That's right. But why can't you do that for him?
I could. I just gotta put forth the effort.
Tell you what. Miss Wiley, can you call Judge Washington before I talk to her? I tell her I'm keeping this case. You are gonna go to school.
Thank you, sir.
So her sentencing date will change. What is it?
We're going to do it December 22nd, 2025, 9 a.m. That's before me. Everything's going to need to be paid at 14B, but so now that this case is mine, when are we going to school?
I'm gonna figure that out as soon as I get out of here, sir.
I heard your attorney tell you that.
I'm gonna talk
What's
to my
wrong?
dad about
Why
it.
are you crying?
That's just like a great opportunity.
What is?
Being able to like not only like get it in front of you, but like be able to go back to school. Like actually, it's just been hard to get my life together, to be honest.
That what?
It's been a bit hard to get like my focus straight, my life together for like a minute.
It's not gonna be that hard, lady.
Yeah. Thank you.
The thing that you gotta do, you just gotta put together. You just gotta do it. You think everything for your dad throughout his life was easy?
No, it's definitely not.
So there came times where he just had to make that first step and then go to that next step. Where were you enrolled in school?
Monroe Community.
Monroe. So their classes, like every other community college, will start back up in January.
This should be the first step.
Yeah. And so you can go down there. You know how to fill out FAFSA?
Yeah.
To get, you know about all of that.
A little bit about it, yeah.
Well, you better find out a whole lot about it. And I want you in classes by January.
Okay.
And when I say that, I don't want any cream puff classes. You come in here with underwater basket weaving or something like that, and I got someplace you can sit until you rethink that decision.
Understood.
Understood?
Understood, sir.
Young lady, if there was anything in the world you could be and would want to be, what would it be? Just
You're gonna think I'm crazy for something.
no, I don't think anybody's crazy. Well, you're an attorney. But I don't think
Just a
anybody's
little,
crazy.
Judge.
But just a little. What would you want to be?
One of my dreams since I was a little girl was to get into like modeling and acting. Just because it's something my brother used to do when he was younger, and I just thought that would be just like a great career path for me.
Okay. And if you want, no, that's not crazy. But if you wanted to follow that dream, why don't you?
I don't know.
Because here's the funny thing. You can have that dream that's what you want to do. The great thing about life and the great thing about education is that as you're going on that journey, all of a sudden you see something else. And now's the time in life for you to be able to sort of grab onto something else and just look at it. Because there's a whole lot out there that you have no idea about. Nothing. I mean, you just don't know. It's a whole world open up. So you're going to be on a journey with me, or you're going to figure that out.
Absolutely.
Got it?
Yes, sir.
Dad, you want her back, or you want me to change her bond? You want it? See? He didn't even have to take you back. All he had to do was say, Judge, take her. You'd be gone. I wouldn't even ask any questions. Bond will continue. Young lady, have a wonderful Thanksgiving.
Thank you for Your Honor.
All right. And
you will get in touch with my probation department down here. They're down the hall on the left. And Ms. Polera will explain to you how I am about school.
Okay. And then any future dates that I need
The
to?
22nd, she said.
22nd. So I'll see you before Christmas. And we'll decide if there's gonna be a Christmas, because if dad comes in and say he's disappointed, you're going. All right?
Yes, sir.
You take care.
Thank you, Your Honor.
Thank you, Your Honor.
Dad, take care of yourself.
Happy Thanksgiving, Your Honor.
Yes, and to you, Ms. Valtez.
Thank you.
All right, I got you up here.
Awesome. I got my feelings.
I don't know what you're saying. Court calls case People versus Anthony Wilson. Yeah, they need the one back. That's their last in custody. Or now, they got one more.
Oh, Ash helps for people.
And Alex,
I did.
good afternoon, Your Honor. Alex Warren, Green on behalf of Mr. Wilson.
You're bringing him.
You state your name. State your name.
Anthony Wilson.
Thank you. Your Honor, I appreciate the court's accommodation in passing this matter. Before we broke, the court asked that I get in contact with the lab in Detroit that Mr. Wilson's been testing at. We were able to do that. Mr. Wilson did provide a sample on November 22nd. The test results have not yet been processed by that lab. But with that said, Your Honor, he is drug tested November 7th, November 9th, November 22nd, which is consistent with random testing once a week, which was initially ordered. The issue is he needs to have these results provided to community corrections by signing a release of information. And if the court is so gracious as to continue his bond, I would make sure that is done. That said, we have no result for the November 22nd date. And I think the bigger issue here is Mr. Wilson tested positive for THC in the first 3 samples he provided, and he expects he'll test positive for THC in the sample he just provided. I spoke to Mr. Wilson, and he is going to take the steps to either get a medical cannabis license or refrain from using marijuana while he's on bond. And he understands that cannot use marijuana while on bond. Your Honor, I would ask the court to consider continuing his bond based on the fact he's made his 2 court appearances. He has not been charged with, or he hasn't been convicted of any crimes in, it looks like, about 10 years based on my review of his criminal history. Mr. Wilson is a father. He has 2 young kids. And when I went back to speak with him, his number one concern was making sure those kids get picked up from school. So we did make arrangements to make sure that happened. Mr. Wilson works 2 jobs. He works for DoorDash and Uber in addition to currently building his home business. Your Honor, I would ask the court to consider continuing his bond. I don't believe he's a threat to the public. I don't think he's a flight risk. And with these bond violations, he's going to get compliant with his bond.
He's gonna what?
He's going to get compliant with his bond and remain compliant with his bond.
What I should do, Mr. Wilson, is I should lock you up for a couple of reasons. One, you're in violation of your bond, but at least you've been testing. Explain to me something though. Because your counsel makes a good argument about kind of letting you go and letting you do these things. Explain to me, when I sent you back, why you had to act like you did.
I didn't act like anything.
Mr. Wilson. Your Honor, when I spoke to Mr. Wilson,
What were you telling these officers? Because all they're doing is following my order. So if you want to maintain that you did nothing, then we'll maintain that and I'll just make my darn decision. They do not deserve to in any way be disrespected.
I apologize for my outburst of what I may have said. At the moment, because someone used my name, I'm going through this instance, so I'm totally innocent. I'm being really drugged through the mud because of this. So I'm very frustrated. And I'm sorry, Your Honor.
I get it.
So
Is that anybody in this room's fault?
I take accountability for my action. I apologize for the way I acted. There's no excuse, but it's just so much on me right now. It's just, I've never been to Ann Arbor in my life. And the 2 times I've been here, I've been in cuffs both times. And I've never been here in my life.
Maybe, can I just say this? Maybe what you should do is just check your attitude. And I'm dead serious about that. Because when I found out what happened back there, you weren't going to see the light of day through Thanksgiving.
I understand, Your Honor.
And you know what's funny about that is? It was the people you disrespected that even started me maybe changing my mind about where you should spend Thanksgiving. Because while you had already disrespected them, they realized that you've got kids, that you want to be someplace.
Yes.
So instead of giving them a hard time, you ought to thank them.
I'll thank them for what they did. Do they help me get in contact with my family to at least check on my kids?
Exactly.
I'm responsible for them, and without me, they can't get back and forth to school or anything.
Right. And they got that, didn't they?
Yes.
And they made sure that you could do. That's the only reason that you're still back there right now.
I understand, Your Honor.
Think before you start doing stuff, all right?
Yes.
And I realize you might be frustrated by this whole process, about everything that's going on.
Totally, Your Honor.
Young man, give it a chance to just work itself through. Because acting the way that you're acting now, those kids are going to be without dad.
You're absolutely right, Your Honor. These couple of hours away from them has been a lot.
Yeah. And think about it if it were just a few days, because again, that's where you were.
I understand, Your Honor.
Are we adjourning this out?
Your Honor, I would request that this matter be set for examination.
So all of the discovery is complete. You have it.
I believe so, Your Honor.
People have their witnesses available the 23rd.
We will try for that date, Your Honor. One of my officers, I'll have to double check with him, but I'll try for that date.
Preliminary examination in person, December 23rd, 2025, noon. That's before me, Mr. Wilson.
Thank you, Your Honor.
So you will have an opportunity to show me if you can use your head about this.
You're right, Your Honor. Yes.
You hear me?
Yes, 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 sir.
And if you come back here before me and that's not it, we're going to have a problem. And when I have a problem with people, who wins?
Probably you do most of the time.
Probably in here, always.
Yes, sir.
Thank you, Your Honor.
Excuse me, is there anything I need to sign before? 'Cause that's the whole problem we're having here.
What do you mean?
So I'll make sure the appropriate releases are.
Oh, the release. I don't have the release. So here's what you gotta do, young man. The place that you're testing,
Yes.
you gotta get a release. Then the public defender can help you. You gotta get a release to them to release the result to community corrections.
Okay.
Okay? The other thing you gotta do is you gotta get on that medical marijuana card, so you're not in violation there.
Okay.
You got it?
Yes, sir.
So it's really simple. Don't mess it up.
Yes, sir.
Let your bond continue. And you know what? Those three folks around you, you need to thank them for your freedom. Because I wasn't gonna do it.
Thank you, sir. Have a happy holiday.
You do the same. Enjoy your kids. Court calls case, People versus Terrence Ginyard.
Prosecuting attorney for the people.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Ginyard. Record again?
Terrence Ginyard, Your Honor.
Your Honor, thank you for the opportunity to speak with my clients again. I think you would like to address the court.
Yes.
Your Honor, I take full responsibility of the violation. Like I said,
what happened?
So the night of the 22nd was her birthday party. It was really
Whose
big.
birthday party?
Stand, please.
Who is it?
Sherelle. This is my fiance, Sherelle Smith.
Ma'am, you could sit if you want. I don't know how I don't even know how he is trying to tell her to stand. How do you do that?
Well, you asked who it was, so
I know I asked her who it was. If she felt like standing, she could stand.
Yes, sir.
If I wanted her to stand, I'd tell her to stand. I don't know what you are in control of nothing right now.
Yes, sir.
All right, go ahead.
So on the night of her birthday party, I cooked, tried to make everything perfect for her and her family. That's from Detroit. They came down, celebrated her birthday at home, had a good time. There was no alcohol around that I seen. Now I did take a cup of substance, I guess, that consumed alcohol. Now I do agree to that. And it was a cup that was around that I had misplaced with mines. Now I do agree to take that. At the same time, as far as battling everything I'm going through, I was talking to CMH. They're working with me. My mom is staying with me now, just as far as her care with my daughter being out of UNIC and recovering well. That is, I just was battling a lot. My first time on tether, sir. I haven't been in trouble in 7 years. Not saying that's a good or a bad thing, but just to bring the matters forward. I've been doing a great job handling myself. I have my own place. I've been there 5 years. I've had this job for 2 years. I'm a sous chef there. I was supposed to be at work today. If I missed this weekend, for sure, I'm out of a job.
Oh, I know.
Understood. But just going through all this, I've been dealing with CMH for mental health. I do have an appointment in 4 days, and she has on record I sent to her with them, so I can get some type of help with mental and some type of treatment. Now, I was going to ask you if it's okay, even if, say, for this violation, I'm not saying it's not serious. It's my first time being on this type of thing. And if I can do like 3 times a day blowing, if I can do any type of outside programs, if I can report to community corrections twice a week, anything just to keep my job and my place to stay. Because I have her with me that stays in my apartment, and I have my mom. And I don't know, like if I'm incarcerated, I'm not going to have a place to stay. Neither will they.
Ma'am, does he talk this much always? Yeah. Does it get on your nerves? Yeah, because about a third into his thing, it was getting on my nerves. But I gotta let him go, and then I could see you there just. So why should I give you another chance? Because normally this is real simple for me.
Only because of my living situation, I would ask your honor, and as far as my job and my commitment to my family. My commitment to my family. That's all. That's the only reason I would not ask for jail, sir, or for this violation. It's just because the commitment to my family. And as far as much as I progressed through the years, even though, like I said, I haven't been here in 7 years, I asked for some type of help, and I'm reached out to CMH. I'll see them in 4 days, and I do have the appointment.
I think Mr. Ginyard speaks very well for himself. But I just want to emphasize to the court he's expressed to me how much pressure he is under supporting all those around him. He knows that this violation has threatened that, and any further violations will threaten that as well. He has children, and he's up in circuit court on a felony non-support case where he has paying significant amounts of child support. So like you said, his mother is staying with him. His mother has kidney cancer.
I'm able to, I'm registered to pay $1,000 a month on top of, I have to pay $9,000 before the end of next year in order not to make it a felony. I'm just going through a lot right now. So I need to keep my job, my place, and to make sure my family has somewhere to go this winter. Please, I beg.
The young lady in the pink is your fiance?
Yes, sir.
Turn around and apologize to her.
Sure, I apologize for my actions and what I've caused.
He didn't even know what he's apologizing for.
Anything that we have on, I'm truly sorry.
That's not even what I wanted you to apologize for. You want to know why did I stop you from talking the first time?
About the cake.
Why did I stop you from talking?
About the cake incident, sir.
Yeah. What were the words that were coming out of your mouth regarding that cake?
As far as an infused cake, sir.
Yeah. But what else was coming out of your mouth? That would lead me to think you need to apologize to her.
That it was her birthday cake.
No.
And that she did it. You were blaming her for what was your weakness, your mistake.
Understood, sir. Yes, sir.
That's the part that I didn't even know she was here. I don't know her, but that's just wrong. You know, and maybe it's the time to say something like this. Sometimes, you know, just stand up, be a man, take it. If you did something wrong, you did something wrong. Don't take your lady and blame her for it, or that she did something and that's why I'm in the boat I'm in. You're in the boat you're in because you're in the boat you're in.
True, sir. Yes, sir, Your Honor.
I'm going to adjourn this probable cause hearing to December 11, 2025, 9 a.m.
Yes, sir.
I'm not going to put him in for Thanksgiving, although I should.
Thank you, sir. I appreciate you, Judge Simpson.
Oh, you don't thank me. You thank her.
Yes.
Because she's the one that's leading me to do it.
Thank you. Thank you. Thank you, sir.
Well, both of them. I ain't going to try to get involved in all that. I'll set your sentencing on it for December 11, 2025 at 9 a.m. on your bond violation. So come back here, not act right, not do the right thing. I still got all that hanging over your head.
Understood. I understand, sir. No, I do. I do.
You know what? You can also thank that attorney that's standing next to you.
Yes.
She was giving me everything to be able to do something with you, because the easy thing would have been just to lock you up.
Understood, sir.
Don't mess this up, but I'm going to change his bond conditions. You're on a scram teller.
I think I've never been on nothing like this.
You're a scram.
He's on a sober link, but he's on a home confinement.
I'm home confinement.
So he'll stay with the home confinement except for work.
what he's gonna do, because here's the other thing, young man. I usually don't let people out right before Thanksgiving, because that's the date that the most alcohol in the United States is consumed.
Understood.
That is why I do not let people out, and I really shouldn't be letting you out. So on Monday morning, part of the order is,
Yes.
he's gonna continue on a sober lane. Then part of the order is gonna be on Monday morning, you've got to report to community corrections for an ETG test. That's gonna let me know if you drank over the weekend.
Okay.
God help you if you did.
I'll be good, Your Honor. I promise. I'll be great.
Okay, we got that. Ma'am, you want him back? You do? Really? Because all you can do is just tell me no. I'll just send it. Okay. All right. Go on and be with your family, young man.